Ma'am, sir, I am seeking apology, Lordship, for inconvenience because yesterday I have circulated the adjournment sheet, Lordship. But what happened, Lordship, on the matter was fixed on 4.
No, you see, apology will not do because I think they are armed with sticks and lathis. Better have an insurance and then make that clear. Yes, but Mr. Ali,
If that is the inconvenience for the additional Solicitor General, then they can fix another date. Otherwise,
we have a Deputy Solicitor General here.
considering the order passed on the last occasion,
No. Don't stand up. I always say something in lighter tone. Not stand up. You agree to a date, all three of you. And
last-
Mr. Balgopal, his convenience also. Please have a consultation and
He was supposed to come online. But like today he's not coming because since he has already made a prayer.
no, it's okay. Agree to a date.
I'm online, Mayor. I'm online.
Yes. Okay, I didn't see you. Yes.
I'm online.
Yes.
My lord, yesterday, because they made a request, and
Yes,
I
Lord.
also asked my government people, so I was informed that only because of this election impending which is going on, otherwise they had prepared for a meeting in Delhi between the central government and the state government officials. Because this time we got, we have utilized it very profitably. So I think that perhaps maybe one of the reasons which was bearing in his mind, I think so. But I have got this clear instructions that we are moving positively. We are moving positive. The Lordship's intervention in the matter, we had given the. I'm not heard.
Please agree to a date.
Last part of May, Lordship, 28, Lordship, 28 May.
That will be too long, my lord. In the second week of May.
Both AZ,
You all agree. We have every day is convenient for us.
both AZ and AGI has discussed, Lordship, and accordingly they have visually agreed on 28 May, Lordship.
If it's not inconvenient to your Lordships, my lord, I will leave it to your Lordships.
why not 27?
27 or 28 May.
Because considering the journey,
Yeah, I understand.
it's more easier, as I have mentioned earlier, Lordship. It's more easier to travel from Delhi to Guwahati than to travel from Kohima to Guwahati, although it is a short distance. Lordship is traveling from time to time. After a long journey again to prepare the cases, little problematic, Lordship. So may I pray that let it be on 27 so that I can travel on 27, 25th, and the 26th I will get some time of Lordship.
Okay.
And let it be a firm date, Lordship, and then let us ensure that the matter do not differ on that date, Lordship, unless it is due to reasons beyond our control.
No, drop of the hat is also beyond our control. So, but okay, 27 then.
Yes, sir.
But no adjournment on that day. We'll proceed despite
Yes.
all odds.
Please,
And- And
we'll
then
do it.
the submissions made by the learned Advocate General, Lordship. Lordship may also keep in mind about the last order which was passed on 14/2/2023. The two queries were made by the court and the parties were directed to address on those points. Those points may be taken into consideration by your Lordship.
Okay.
And once second clause B, that condition is decided, I believe the entire matter will be decided by that.
I have furnished my written submissions, my lord.
Yes.
And basically, the learned amicus was also going on those lines. In the next hearing, I shall clarify first these 2 points, unless the learned ASG wants to complete.
No, no, in fact, you also be prepared on merit. Along with
Yes,
this-
we are going to be on merits.
Huh.
We'll be on merits. Sorry for the inconvenience that has been caused to your lordship. I would have definitely come, but
No, it's okay.
request.
Heard Mr. City Jamil Leonard Amicus Curiae,
I'm assisted by
Mr.
Aliba Ozakam.
Aliba Ozukum, Learned Counsel. Also heard Mr. K.N. Balgopal, Learned Advocate General for the state of Nagaland, assisted by
Monica,
Ms. M. Keshi, Learned. You are senior government advocate,
It will be.
additional
additional
advocate general.
advocate general, Nagaland. Also heard Mr. S. Datta, Learned Senior Counsel, assisted by Ms. S. Mushari, or Mr. S. Datta. Mr. S. Datta, Learned Counsel for Respondent number 7. And Mr. K. Mr. K. Kalita, Learned Counsel for Respondent number 8. An adjournment memo was circulated on behalf
Mr.
of,
Ashish Dasgupta is
oh,
also
sorry,
for petition number 7.
along with you.
Yes.
In precedence, Mr. Dasgupta's name will come first.
Yes.
And then the counsel for the High Court is also present.
Oh, acha. Okay, okay. Ms. A. Dasgupta, along with Mr. S. Datta, Senior Counsel. As well as Mr. A. Please write your name. Please write your name. I'll make a mistake otherwise. Then standing counsel for the High Court. Next, memo of adjournment was circulated on behalf of assistant, on behalf of additional Solicitor General of India. Full stop.
Mr. Sanjay Jain.
Mr. Sanjay Jain, that is additional Solicitor General of India for respondent number 8. Full stop. The learned counsel for the learned senior counsel for the respondent number 7 expresses some urgency in the matter. Next paragraph. Be that as it may, the matter stands adjourned today. Next paragraph. Next paragraph. List on 27/5/24. So it is made clear that the matter would not be adjourned on the said date. Stop. The along with merit, the 2 queries of the court as recorded in the order dated 14/2/2023 shall also be addressed on the said date. It's just a thought occurred. If you all agree, we must take care of Mr. City Jamil. He is an amicus curiae and has been compelled to travel on a lot of occasions.
Definitely. Whatever your lordship says, we'll take it ourselves. There's no problem. State will take it.
Just suggest what would be reasonable.
Your lordship takes whatever it is. agreeable to us. We'll do it. It deserves kind attention. Your lordship may pass it in the order, madam. There's no problem.
It's okay. Having noted that the learned amicus curiae has been traveling on several occasions to attend this matter. The court is inclined to allow him an honorarium of rupees 25,000.
Lordship, that may not be inserted. On the last occasion, my Lord Justice M.R. Patak has also passed an order that the fees of city chamber shall be paid from the Legal Services Authority.
Okay.
But then that provision is only 10,000 for the entire case. So I would prefer to conduct this case as a pro bono.
Well, we will take care of it, but state will
I'll
take
be
it.
pleased.
Not an issue.
If Lordship permit me to do that,
No, that's
I'll
okay.
be
We
more
just-
honored rather.
Sure.
It's okay.
It is interesting also. I also learn in the process and I feel it as a duty.
No, but there's a lot of cost of conveyance.
That is okay.
We will take care of it, madam. There shouldn't be any problem. He's involving himself deeply
Let
in
that
the matter.
responsibility be left with the Leonard Advocate General.
Yeah, I will take care of it. I'll do it. No
Okay.
problem.
Then we don't say anything in the order.
Otherwise, I can,
Yeah, we'll take care of it, madam. I will discuss with him
I
and do
feel
that.
honored if I do it pro bono.
Oh,
No problem.
Just say, we intended to provide some honorarium to the learned amicus curiae. So, however, he has declined and agreed to do it pro bono. It is politely declined. Maybe to do it pro bono. We record a, we we appreciate the gesture of the learned amicus curiae. But nevertheless, we leave it to the state government of Nagaland to take care of the conveyance cost, huge conveyance cost, which is being incurred by him, even for his pro bono, even for his pro bono appearance. List on 27 and 24.
I have only one request, madam.
Thank you, Mr. Valgopal, for making that offer.
No, we should. After all, he's a person who has taken deep interest and is doing it very well. We should honor that from our state also. To be done. But
Yes.
No, I have only one request, my lord. Last time this matter was mentioned by Mr. Datta, I think. And whenever they are mentioning it, they should inform the state also. Sometimes when they mention it in our absence.
Now that is not required because
No, that is not required. That is okay.
because you see there was some difficulties. The
That's
bench
it.
was not available. The constituents of the bench were
Right.
constantly traveling in different places.
Right.
So the matters could not be listed.
No problem.
Then we have been given certain rosters where again breaking up the bench and then having this bench was also difficult.
Yes, sir.
Okay, thank you.
Much obliged, Lord.
Some urgency is there. Yes, then today quickly. I have a similar payment. Today, except second one. Item 15 and. File it. Yes, filing number is there. Obliged. But item 15 and 16 can it be taken after 3 weeks? 15 and 16. Well, I have taken the consent of the other side.
Meet Peter Worship. My lord, I have a similar prayer, my lord, pertaining to a writ petition relating to settlement of a fishery, my lord. In spite of court's order, wherein this fishery was directed to be settled by inviting fresh tender, they were again on 15 March, they have settled it on daily basis, my lord, and given possession to the private respondent. With some urgency, if your lordship can accommodate today, my lord. We have very small issue, my lord. I'm deeply obliged, my lord.
May it please your lordship, I beg to mention item 17 with the consent of the other side. Lordship, there's some process of settlement, lordship, the matter may be taken up after 3 weeks. Lord. I bought her.
Also, I beg to mention item number 36. Also, 36 with the end is not available today, Lordship. I have circulated the adjournments. Lordship, any date, Lordship, after vacation. First week of March.
Yeah, please, your lordship, with the consent of the other side, lordship, I beg to mention item number 9, your lordship. Lordship, we have misplaced the file, so lordship, we need some time to reconstruct the file, your lordship. Lordship, kindly matter may please, after 3 weeks, in the meantime, we'll take instruction, your lordship.
Item number 9.
9. PNRD department, lordship. With the consent, lordship.
May it please your lordship. Lordship, with regard to item number 5 and 6, my lord. Lordship, we have preferred these two matters for mediation, my lord, and accordingly we have submitted an application before the Legal Services Committee, my lord, with the consent of the other side, my lord. So, lordship, I pray that this matters may be taken up in the next local adalat, my lord, the coming. Yes, we have already submitted an application, my lord, before. Yes, my lord, yes.
Your lordship, I am appearing for respondent 1, 2, and 3.
B. Bora. Yes, the next Lok Adalat will be held on 11th of May, my lord. So, yes, my lord. Any day thereafter, my lord. Another prayer, my lord, regarding item number 35, my lord. We have taken the consent of the other side, my lord. This matter may come up immediately after vacation.
35 lordship, we have received record lordship. So my lord may fix on after 25th lordship. I have some difficulties lordship up to 25th lordship. After 25th lordship. Lordship.
On a hearing day, my lord, on 30.
Oblige, your lordship.
May it please your lordship. Your lordship, in item number 18, this is the appointment of arbitrator application under 11.6. Your lordship, some compromise talks are going on between both the parties. So may I pray the matter may be restricted for 2 weeks, your lordship?
Yes,
Is
yes.
there, your lordship?
Deeply operative.
May it please your lordship, I beg to mention item number 13, my lord. My lord, the matter is become infructuous, my lord, because the lease of the petitioner was cancelled, my lord. So may I pray for closing of the matter?
Oblige. May it please your lordship. Lordship, I beg to mention item number 10 and 11 from today's daily list, my lord, with the consent from the other side, my lord. In item number 11, my lord, the respondent number 5 have filed their affidavit, my lord, in opposition, my lord. So we want to file reply to that, my lord. So 4 weeks time may be allowed, my lord. Yes, Upadhyay, my lord. No, my lord. I'm deeply obliged, my lord.
Daily list item 1 for motion.
This case has wrongly been listed in motion column, your lordship. Notice was earlier issued, your lordship. Your lordship has issued notice by order dated 18/1/2023. My prayer will be, your lordship.
Lordship, we are for Dima Hassan.
They have received, your lordship, some instruction, I was told, your lordship. Your lordship may take this matter, your lordship, after Bihu vacation, your holidays, your lordship. In the admission column.
Lordship, my senior is on labs right now.
He told me that, your lordship.
Yeah, we have received the
He
instructions.
told me that he has received instructions.
We have received instruction.
On, may I pray for a date, your lordship?
Just.
I mean, 29th of April.
My lord, my humble prayer, because I'm appearing on correspondent number 4 and 5, my presence will be required. That particular 29th, I have a personal difficulty. So that is on
First of May.
1st of May. And I'm appearing on correspondent number 4 and 5.
Lordship.
Correct.
Deeply obliged.
Oblige your lordship.
Item 2.
Before my learned friend starts, my lord, I have for the private respondent, I have filed an affidavit yesterday, my lord, that has not come on court.
Lordship,
The instruction.
Lordship, daily basis was is a very temporarily we have given Lordship, because Lordship. The order is made. Lordship. Lordship.
My lord, I'm not getting your lordship.
Contractual matters, I think.
I think. Yes, in one matter, yes, my. Yes.
Lordship, here, Lordship, that is not an effect. We have processed that auction. We have also. No, Lordship, that part was not unaware about it, Lordship. Regarding his bid, Lordship, regarding 8,000, he has placed in the court, Lordship. But here, Lordship, MCC has come up. He has missed the bus. Lordship, he should have come before 15th of March, Lordship. He should have come if he while filing the application, Lordship. 3 representations were there, but he has not quoted anything, and he has not quoted that he is the fisherman community, 100% fisherman. No documents were submitted by them, Lordship. So we have taken the view, Lordship. It is purely temporary. We have already processed it. Due to MCC, we could not go it. Model code of conduct has come. So instruction is also there, Lordship. There is nothing inherent, Lordship. It is only for this purpose, Lordship. It is also apparent from the page number 50. Lordship. 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 No, Lordship, there was a court case, Lordship, prior to that. In this case, Lordship, there is a court case, Lordship. Lordship. Not, no, Lordship.
Yes.
Gotcha. That's it. That's it. I will put it on here. I will fight. That's it. That's it. Lordship, I will file this by this instruction, Lordship. But let me allow Lordship one thing, Lordship, one prayer, Lordship. Let me allow to file this by way of an affidavit. Lordship. 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 Lordship, there is a difficulty, Lordship, in our case, Lordship. The tender process is being done by a tender is being. Lordship, we are not against NIT, Lordship. Lordship. Lordship.
My lord, just may I, my lord, because it's how I projected this case, and there are judgments of this court in what manner it has procedure, in what manner it has to be followed. In case of daily settlement, kindly see my writ petition at page 27. They said certain documents we have not. I have not come across in my career in a day-to-day basis. They certain documents are required by department, and if they require documents, it was their duty to issue a notice to me. These documents are required. I understand regular settlement, my lord, documents are required. What is required is actual 100% fishermen, neighborhood. These are what they said that you have not submitted document. I'll show it. See kindly 27. See 27. Page 27.
Fishery is fishy. Lordship used to say. Fish is fishy, lordship used to say. Yes, I know. Lordship. Lordship.
My lord, 27 is my residence certificate. Just showing it. You don't. 29th is my fisherman experience certificate and fishing experience certificate at page 30. These are which I have been brought. Now, my lord will kindly see page 32.
No, lordship, it is here. It is very specific, lordship. We have instructed the DC. Actually, our tender. No, lordship. For daily, they have to pay us. But whatever I could. Yes. It is for what for per day 6,000 is I could not get it.
This is the whole.
No, lordship, we never go for this daily basis. Lord. We never appreciate, lordship. We never appreciate. This is a very peculiar situation. That's because after the court order, lordship. Lordship. That's it. That's it. Lordship. Lordship.
I'll tell your lordship how they have done it. Your lordship is right. Daily means daily. They doesn't do it. They is a settlement, temporary settlement, which is daily day term. It's given for 5 years.
No,
It has a please let me. You say no. There's no problem. Just hear what I am telling the court. Court can just give me put a question. I'll reply. Page 32. This is the dispute in question of this fishery, my lord. Kindly see page 32, my lord. Everything will be clear, my lord. Page 32. This is a fishery in question, my lord. Page 32. Lordship has seen there are linked case. First is 8281. That is 2022. Kindly see the link case. This is the case which Sureshwar Means Samabay Samiti Limited has filed. And his case was an extension was given on daily basis. Now kindly see next page 33. That is next page is link case 8310 of 2019. Kindly see the link case at page 33. 8310 of 2019. Lordship got it. Now I'll tell my lord. Your lordship, this 8310 of 2019, initially this one Chandakola field,
My lord will kindly see at page 33. The party is Chandakola Bill Fishery Cooperative Society Limited. Now, in 2010, my lord, NIT was issued in respect of the same fishery in question. And it was settled with Chandakola Fishery for a period of 7 years. For a period of 7 years. Now, settlement order was passed in 2012, but it was settled for a period of 7 years, which expires in 2019. Before expiry of the fishery, the Chandakola approached the government that they have sustained loss, so there has to be an extension to be given by them. If you give it on, because there is a provision under the fishery rule, extension can be given. So they made an application. This application was pending. Nothing has been done from the government. They filed a writ petition before this honorable court, saying that we filed an application for extension. Please consider, in the meantime, when the 2019 period is over, now the government issues an NIT, fresh NIT, in respect of the same fishery in question. Now, the order passed by this court was that notice issued. In the meantime, they will not settle it. They will not settle it. In the meantime, on daily basis, extension was given to this Chandakola fishery, not for a period of 1 or 2 years. It was given for a period of more than, I think, 4 to 5 years. 5 years it was given daily. And what rate? 3,000 something rate, 3,800 something rate, which was given in 2012. Now, Suresh saw by 8281, I think my learned friend was representing. He comes and he files that how an extension has been given on a day-to-day basis. There should be an NIT has to be floated. NIT to be floated. That was the issue before this court. Now, there is a finding of this court. Kindly see the finding of this court at paragraph 15. What was the finding of this court? Public exchequer, why it is important. Kindly see at page 38. Only one paragraph, kindly see, my lord. See, I have heard, as can be seen from the facts stated above, the petitioner herein prays for a fresh tender to be issued for settlement of fishery in account of fact. Settlement of fishery with respondent number 7 is ended in the year 2019. Further, the extent of fishery with respondent number 7 on daily basis was subject to decision of this court in 83110 of 2019. See para 16, my lord. See para 16. Though the council of respondent number 7 has tried to make out a case that lease of the fishery has been extended for 7 years till 2006, the same is not borne out by the order dated 23/12/2019 issued by Deputy Secretary Fishery Department. Interestingly, while the respondent number 7 has quoted 1,61,000 something, it is a bid amount pursuant to tender notice 1 crore, I think, no? 1 crore. Tender notice dated 15/11/2019, which works out to 6,301 per day. The state respondent have granted extension to the leasee of the fishery with respondent number 7, while order dated 23/12/2019 at 3,080 per day. The above clearly shows that the public exchequer has made a great loss for reason best known to the state respondent, who had given extension of the lease to the respondent number 7 on the basis of a rate given in terms of tender notice dated 25/11/2010. It is further interesting to note that respondent number 7 has made a challenge to the NIT dated 15/11/2019 in WPC 8736 of 2019 by praying for direction not to give effect to the said NIT dated 15/11/2019. However, the Council of Respondent number 7 has now made an alternative prayer to consider bid of Respondent number 7 in terms of the NIT dated 15/11/2019 and to give effect to the NIT dated 15/11/2019. Conflicting stand taken by respondent number 7 is not permissible in law, as a person cannot be allowed to blow hot and cold, approbate and reprobate at the same time. My lord, when this was chance, he took a chance, saying that no, settle with that 2019, and comes to the court extension, the rate of 6,000. The court said you cannot blow hot and cold. Now, the finding is at page 41. Kindly see, my lord. Page 41. 41, paragraph 19. The above being said, the earlier WPC 8736 has been withdrawn by respondent number 7, wide order dated 29/1/2021. Keeping in view the facts, interest of the public exchequer will be the best served if a new tender notice is issued by state respondent
and a fresh settlement of fishery is made, which would be commensurate with the prevailing market rate, state restaurant is given liberty to initiate a fresh tender notice for a settlement of fishery. Due to a reason stated is dismissed as withdrawn, nothing development the impugn order, so and so is set aside. So that was set aside. Now, after this order was passed, they challenged it. Chandakola challenged it by a writ appeal before the division bench at page 43. Kindly see 43, my lord. See paras 17 and 18. 17 and 18. Two paragraphs at page 50. 50 of division bench. Paragraph 17. So far as the observation made by learned singers in the impugn order to the effect that interest of public access will best serve if a new tender notice issued by the state restaurant, a fresh settlement of fishery in question is made, is concerned, we do not find any illegality in sale. True, it is that in the year 2019, government has fixed the value of fishery in question of so and so, but in all probability, it is not in the present rate of fishery in question. With the efflux of time, rate might have enhanced. Last paragraph 18. One thing which cannot be ignored in the pursuant to NIT dated so and so, appellant society has quoted 1 crore so and so is bid amount of settlement of fishery in question, which works out to 6301 per day. But the extension of the lease in question was granted to appellant wide order at rate per day. Appellant society is running the fishery at that rate till date. In view of the noted finding record by learned single judge, a public exchequer was put to great loss cannot be said to be unwarranted. So in that view of the matter, when it was sent back, set aside at page 52, my lord, 29th of February 2024, an application was filed by the present petitioner. Kindly see, my lord, at page 52. Now, that is a subject. Application temporary settlement of so and so on daily basis as stopgap as per existing till finalization of regular settlement through tender dated so and so. Now, if you kindly turn to page 53, my lord, 53, first paragraph, that sir, the regular settlement of the same to tender will take some time. In this, it is obvious, fishery group number so and so is to be run on temporary daily basis till finalized regular settlement. Fishery group number so is immediate neighborhood and adjacent to our lease so and so. Our message Garamari Gaon Panchayat so and so is ready to take the fishery group so and other fisher on temp till finalization of regular settlement to tender by accepting, my lord will kindly note down, by accepting the rate of the revenue fixed by authority as per rules. So we made it open to the government. Whatever you want to fix it, you can fix it. Now kindly see, so that government can get due revenue in due time, our society is ready to follow the norm as instructed by the competent authority. So we have given this application at page 53, but at page 54, repentation, sorry. See at page 54, 4th of March, 2024. Now, kindly see page 55. In bold letters, 55. Consequently, the daily basis order in favor of Chandakola Bhai, order dated 23/12/2019 is withdrawn with immediate effect. DC will take over position of fisher and keep it as khas until further orders. So they said no, nothing doing. Your application, whatever, we take it as a khas till we decide a regular settlement is being made. This at page 56, 8th of March. Kindly see, my lord, 8th of March, 2024, second paragraph. Now, in view of the above instruction of government as well as the order passed by the Honorable High Court in aforesaid cases, physical possession of so and so in respect of fishery Dharnat Brahmaputra under so and so deemed to have taken from said fish lessee, because immediate and it is directed, none will be to operate fishing in the said government fishery until further order issued from the government. So now, same date at 8th of March 2024 at page 57. Now, the one hand, the deputy commissioner kept it as a khas. Now, at 8th of March 2024, order is issued by the government giving a temporary settlement to my learned friend. Kindly see, my lord, at 57.1. 57 down below, page 57.1 is the private party. The society has taken its claim white petition dated offering daily basis rate of 10% above bid value quoted by Chandakola bill at rupees so and so based on NIT issued by which comes to 6932 per day. But the process of regular settlement could not be completed for legal other issue at DC level, and the issue hence proposal was not submitted to government as per documents submitted the application. It appears that so and so is a member. 600 meter all have experience. All members are now. Number 2 is the petition. See, my lord, society has offered to run it on daily basis at any rate fixed by the state government, by settlement authority. Or from the record submitted with the application appears, society has been settled with 60% government fisher, namely so and so, on regular basis, which adjacent to instant fishery. Society has not submitted any other document record except IT Chalan so and so. So rest story is number 3. So this was settled. The only 2 grounds which they said that you have given any rate, absolutely no problem, but you are running one fishery for 7 years and IT returns was given. I'll give a reply to this, my lord. Now, kindly see at page 59. In this connection, page 59, last 3 lines. In this kind of settlement authority took his consideration the views, opinion of the Honorable High Court to link as a related settlement of so and so, wide or para 32 and 34 of the judgment. Now, this reply of the government saying that you have been settled with one of the fishery. Now, at page 60, kindly see page 60. This is a settlement in favor of the petitioner. At page 60. This is 2022. Now, if your lordship kindly turn to page 64, see page 64. 64. Second paragraph. Accordingly, government is free to settle Dhar Brahmaputra fishery with Mr. Dharnar Brahmaputra so and so for 7 years with effect from date of handing over for position after completion of all equality. This is settlement in favor of the private respondent, my lord. What I am saying that you are saying one hand that you are running one fishery, that's why we are not giving it to you, one of the ground. Now, on the other hand, in 2022, settlement is in favor of the private respondent. That's what I am showing at page 64. Kindly see, Mrs. Dharnar Brahmaputra so and so for 7 years with effect from date of handing over formal position after completion all required formality as per provision of Assam fishery rule by taking over the position of fishery from existing lessee Gauripura RC, which was allowed to run it on 10% above existing rate till regular settlement so and so. So you have also settled with one of the private respondent. How can you take that? How can you pass that order? 65. It is our settlement order. Page 65, kindly see. This is my petitioner settlement order. 15 November 2022. Kindly see at page 69. Second paragraph. Accordingly, Government and Fishery Department as settlement authority of 60% government fishery is empowered under Rule 12. So and so is pleased to settle so and so to with Messrs. Geramari Gaon Panchayat means Sahabai at the offered value for 7 years to be counted from the date of handing over position of the fishery. So the decision which has been taken by the government not to settle me because you are holding already a regular settlement, same applies to him. Now, my lord will kindly see at page 70, one of the bidder, maybe he is not there in the court. He has quoted a rate of 7,000 at page 70. Yes. Page 70, one of the bidder comes before the authority saying that I am giving 7,000. That also not accepted. That means, my lord, now the question is, boils down to 2 points. One point is that my rejection, any rate you have given, will not accept it, any rate. You put it any, that's what the wording. So I kept it open, 8,000, 9,000, whatever you feel it. Now I have not come across that. If you want documents, you could have written to me that these are documents we require. They have not written anything to us. And I have not come across in a day-to-day basis documents. What is required? 100% actual fisherman, you have to be neighborhood of the fishery. It is a fact that we are neighborhood and 100%. Meters will not count. How many distance meters is not counted. Now, at page 71, in respect of some other fishery, how this court dealt, kindly see, my lord, in respect of daily settlement. See at page, I think that order was passed by this court, 36/2023, at page 72. See kindly at page 74. See 74, para 7. Be that, Lordship got it. Be that as it means, the petitioner having taken to consider the contents of the impugn is deemed to have taken note of reduction of fishery and be taken so and so. Court is inclined to close the writ petition motion say without issuing notice so and so by allowing the petitioner to submit fresh representation before the joint secretary, which is offered to run the set on daily. It would be open to respond or find any other prospective bidder to make a counter offer. What they could have given, my lord? They could have said, make a counter offer. Now, kindly see at para 8, it is provided petitioner respond now 5 as well any other prospective bidder including the clients of so and so to appear before a joint secretary government of Assam. Said authorities shall have right to put up a notice to the notice board in the office of District Fishery Development Officer and District Fishery Development of Tinsukia and to inform all concerned to submit their bid in respect of so and so on daily basis settlement till the tender process directed by this court by common judgment and order dated past is brought to a logical conclusion. Before parting the record, the court takes serious note of the fact that by impugn said judgment order passing WCC direction was issued to effect the entire exercise is putting the scheduled fishery to sale shall be completed within 3 months from the date of the say order. So and so judgment 3 months has expired. Therefore, state authority in fishery appears to have not complied with the order of the court in letter and spirit. Therefore, the court is inclined to issue a fresh direction to so and so to ensure the said order and connected cases complied with the letter and spirit. So, my lord, they could have, all the prospective, they have counter offer will be. Today in the court, when the matter came up, the court said, what is the rate you are trying to offer us? I said, we'll offer 8,000. This is a daily settlement. Public exchequer is very important. That's what the single bench upheld by division bench. Today, a rate which is given by 6,000 and the affidavit which is filed by the private respondent to the effect saying these documents you have not submitted. They are not the government. Government has to tell me which governments the documents are required. In a regular settlement, yes, those documents. I have not come across in a private settlement in a day-to-day basis. The documents are required. If it is required, very well. Give us an offer. These documents are required. Intimation has not been made. What is the order that has been passed by this court? Put in a notice board, you hang it. All the prospective. There are applications which has been made. Bring those bidders. Who is the best counter offer has been made. Today I am making a counter offer in the open court. Why the fishery department is not accepting 8,000? Why they are not accepting 8,000? Why they want to settle with 6,000? Something odd. Till a regular set. And once the government decided to take cast position, okay, my application, this is my submission, my
Lordship, kindly go through this documents, page number 70, Lordship. Page number 70, Lordship. Kindly go through that. 70, Lordship. 70. This document is not, we have not received. No, Lordship, may.
It was done, this fishery, 2012. settlement, I'll give the date to your lordship. That settlement order, which was
Lordship,
issued,
you are not
was
hearing, lordship,
15/12/2012.
Actually, voice is not coming, lordship, Mike. We are finding difficult. Yes.
Yes, you are now getting the voice. You're now getting the voice.
Yes, lordship.
Ah,
Actually,
yes, okay.
we all are not getting the
No,
voice.
it's okay.
My lord, a very lighter vein. Sometimes one of the client I remember, he came to the chamber and we certain instruction he was giving. But when the question of fees comes, he said, I have not heard what you said.
No, lordship, we both. My sir was saying, lordship.
Lighter vein, I am thinking.
So Dwayne sir was saying the court master.
That's a good example.
Lordship.
No, 2012 was the last settlement made
Lordship.
in this. Okay.
Lordship, he will say, my sir will. My lordship, here, lordship, one thing, for page number.
Page 70, I'm there.
We are not of this record. This petition we have not received, lordship.
This
Petition we have not received. And I am for the veracity of this document, lordship. Kindly go to the another petition, lordship, page number 52, lordship, their application. Here we have stamped it, 52, lordship.
52.
52. 52, we have the office of the commissioner and secretary, fishery department. Stamp is also there, lordship. Here, lordship, by
Just a moment.
while receiving that application.
Just a minute. Just a minute. Page number
52.
52.
52 and 70, lordship has to tell you.
Yes.
52, while receiving this application, we are admitting this application, lordship. We have there is a stamp also there. Office of the commissioner and secretary, this full, lordship.
Okay.
Here, lordship, this application we have not received. I have contacted the office also.
Okay.
And here no stamp is also there. By this application, the projection of the petitioner is that we have some malafide intention. That is not a part, lordship.
Okay.
Because we are not aware of this application, lordship, 7,000 rupees.
Okay.
We would have given it, lordship. Otherwise, if everything is all right, lordship. We are not about this. We have nothing to hide, lordship. Here, lordship, one measure part, lordship. Kindly go through that part, lordship. Page number 59, lordship. I'm
59.
Last part, lordship. It is may I read, lordship?
Yes.
Plus, it is stated here that above arrangement is purely temporary and can be withdrawn at any time for legal or administrative reasons. Such temporary arrangement does not confer any right on the lessee for regular settlement of the fishery. Lordship, we are not for regular settlement. This is because of division bench order.
That's the difficulty. If you want to give a temporary settlement for 5 years, make it
No,
known to everyone.
but he has participated, lordship.
Yeah, that's okay.
He has not quoted the rate, lordship.
I'm not on X or Y.
Lordship.
The question is
Otherwise,
that if you are giving a settlement of daily basis
lordship,
for extensive term,
lordship.
please advertise it.
In future, lordship, okay.
Not in future. Now you'll get an order.
Lordship.
It cannot be done. I'll prohibit. It can't be done. This daily settlement basis of fishery for a long term exceeding 6 months, sorry, 3 months
Lordship.
will not be permitted now.
Lordship,
We'll stop it for every times to come.
Lordship, here, Lordship, we would have given him, if you quoted 8,000, nothing nullified, Lordship.
No, he's quoting it in court.
So, Lordship, now we cannot go for it because MCC is there, Lordship.
Oh, we'll permit you.
Lordship,
We'll permit you even on the day of election if you want to have a.
Lordship, then also, Lordship, we have already.
We'll do it.
Lordship, here, Lordship, he has.
Code of conduct will not come into way.
My submission is that he has missed the bus, Lordship. He has missed the bus.
We'll call it back. Don't worry.
He has missed the bus,
We'll
Lordship.
call it back. You see, a bus which goes on
Lordship,
returns back.
Lordship.
Have you seen a bus which goes on and never comes back? Even Airbus comes back.
Lordship, but here, my submission is that, Lordship, by quoting in the court, but he has not quoted in the department, Lordship.
That's okay.
My submission is that, Lordship, he should have quoted in the department by filing a proper application that we are quoting 8,000, 10,000, but he has
I'll
not
take
quoted.
care of that. Don't worry. Last time, you see, this order which came was at the behest of Mr. Chaudhary. That last order which Mr. Das was reading.
Yes, my lord, I filed the writ petition saying that, my lord, there should be, my lord, an IT.
Yes.
Open tender. That was my case. And accordingly, my lord, this honorable court allowed that there should be an open tender. And that has been, my lord, directed. Now the situation has arisen, my lord, after the order was passed for regular settlement, because of the circumstances, more particularly the election code of conduct, he cannot do it. Now this writ petition has been filed.
Yes.
My lord, this writ petition has not been filed challenging the power of the authorities to give settlement on day-to-day basis. That is not the prayer, because he is also, my lord, one of the applicants who have filed the application for day-to-day basis settlement. First, your lordship will kindly come to the order challenged in this writ petition at page 57.
I'll show you something. Mr. Das. This is the order of the Supreme Court I was referring to.
Now, what happened, my lord, in this case? In fact, I was a party in the, my lord, before this court. Then, my lord, the division bench of this honorable court held that settlement cannot be given on day-to-day basis. Against that, my lord, this SLP was filed. And the honorable Supreme Court had allowed to continue on day-to-day basis, prima facie being satisfied that it can be done. Thereafter, my lord, in fact, the matter had become infructuous because in the meantime, regular settlement was done. And therefore, there is no final order in this.
No, there was no settlement yet. That's why I asked that question. First, I started with asking question when it was done, 2012.
Yes.
Then I got this order.
There was no settlement at that.
So therefore, even an undertaking before the Supreme Court that the state government would go ahead with the tender
Regular settlement
was never complied with. That's why I said the election code of conduct will not come in the way of the court.
But this is in respect of, my lord, another fishery.
This fishery. Because the number has come. Because the number has come from his instruction.
Yes, yes, yes.
So once I get some document, I read it.
Because of the, my lord,
document which was
interim orders, Sandrakola filed, my lord, petition. Their petition was, my lord, very cunningly drafted. They wanted that in 2019, we had given our tender. On that basis, the settlement has to be given. And they also wanted to run on day-to-day basis. There are several orders. And because of those orders, my lord, the settlement could not have been done. Therefore, we approached that let there be tender. And that was allowed.
So
Now,
this is a case where US private respondent number 6
yes,
and the petitioner are in the same boat. Both of you want a regular settlement.
Yes. True, man.
So permit that.
Now, if your lordship directs that the regular settlement the NIT should be issued, even during the election code of conduct, my lord, there is no difficulty in that. The only question is, my lord, between the date of settlement and the present day, there will be loss of revenue. And that is the reason why, my lord, three parties have.
Let the fish live. If there is no fishing, we'd save some life in the planet.
My lord, government revenue is the consideration.
They are not worried about, the government is
No,
very
your
happy.
lordship, primarily your lordship is considering whether the legality or illegality of this order, my lord.
No, I am not on that.
Right.
The only anxiety is that when the state government goes to the Supreme Court and says that we are finalizing a tender and they don't do it, then their action becomes questionable. Each and every officer of the fishery department are under scanner. Why they have not done also calls for an inquiry by the Vigilance Commission, by the Vigilance, State Vigilance. Once they go and they give an undertaking before the Supreme Court and they don't do it, tell us why not an inquiry should be made through a vigilance department.
Your lordship is right, but then perhaps, my lord, their defense will be that they are in the interim orders passed by this court, my lord. That will be their defense, perhaps.
They could have asked for, you see, once they give us, please tell us.
Yes, they could have, my lord.
If you produce before this court today, an undertaking given by before the Supreme Court that they will do a tender, just tell me, do you expect that even after that, I would, while presiding over a bench, to stay the matter?
My lord,
Judicially, it will be judicial impropriety.
my lord,
When
we
the
were
Supreme Court-
fighting. We were also, my lord, fighting for the NIT, my lord.
So
And
because once you don't comply with the directions, the state government doesn't comply with the directions or undertaking given the Supreme Court of India. This is this would be what you call encouraging indiscipline in the government.
Your lordship is right, my lord. Your lordship is right. But then, my lord, I do not know, my lord, that eventually I was asking them what happened to the Supreme Court because of the interim order, the day-to-day settlement was continued. Day-to-day settlement was continuing. And I wanted to
disturb when seniors are arguing.
I wanted to know, my lord, what happened in that before the SLP.
No,
in the
whatever has
Supreme
happened
Court?
is something else.
Yes.
Now in their note, they have referred to the Supreme Court order.
Yes.
That is why we were compelled to get a copy of that order.
Yes.
Now we have this order before us. It contains a very simple one line. The state of Assam is also directed to expedite the process of auction as already been directed by the High Court. Therefore, violation is not only of the order of the High Court, it's also a violation of the directions given by the Supreme Court of India.
Right.
So that itself is good enough to ask for a vigilance inquiry. Now, Mr. Sharma will now address why not. You give.
In that event, my lord, I do not reply to my learned friend submissions now, my lord.
No, because you see, you may make a reply. You see, you are a senior counsel. I am not stopping you from arguing. It's not that.
But the point your lordship
my
is taking-
difficulty is that I can't keep my trap shut.
True, my lord.
So I like to interact, and therefore I have started interaction. I could have kept silent and let something boil in my mind. But the intention is that if I spell it out, you will be in a better position to assist the court in arriving at a decision. So I am not stopping you for a moment, but the only anxiety which is coming up,
I
2019 order. If the Supreme Court is making a direction in 2019, this SLP is directed against the order of 27/9/2019. So 27/9, we are now 29/14. It is almost 5 years.
5 years, my lord, that party has reaped the benefit, my lord, in spite of the Supreme Court's order.
So that's the anxiety. The only question of the court is, irrespective of whatever has been addressed by Mr. Das, the anxiety of the court is to know from the fishery department that a daily settlement will be for how many years?
No, that is, my lord, clear, made clear in the order itself, my lord. In the order which has been impugned here, that has been, my lord, made very clear, my lord. May I take your lordship to that, my lord? Page 58, your lordship will find last but third paragraph. Last but third paragraph at page 58.
Yes.
So government is of the view that the interest of government, that in the interest of government revenue, temporary arrangement of running the fishery may be resorted to till regular settlement.
So now we have a, what you call, this is so vague. So that any person at a drop of a hat approaches his court, obtains a stay. So it will continue.
That
Let
happened
us-
earlier.
That happened.
That happened earlier.
And there's no, we can't restrain people from coming to court.
True.
Correct. So what is the way out?
But at the same time, my lord, the last paragraph, DC Dhubri will take immediate steps for handing over so and so, and my lord, the direction has been to, my lord, go ahead with the regular settlement NIT.
So therefore on papers, nobody disputes the order of the High Court to have a regular settlement.
Yes.
Nobody disputes the direction of the Supreme Court of India to have a regular settlement. And then we are not, looking the sun has not, what you call, dawned.
But even if, my lord, while agreeing to whatever your lordship has fallen from your lordship, my lord, even if your lordship directs today to issue an NIT, and by the time my lord, the process is complete, the government should not lose the revenue. I am making this submission in my interest, but the fact remains, my lord, that will take some time. The NIT has to be for a period. Then, my lord, settlement, your lordship may direct that within 15 days you complete everything. But this period, my lord, why should the government lose revenue? That is my submission. More so when, my lord, there is transparency in that order.
Because then the government will be compelled to make an auction. When we stop everything, then they will wake up.
No,
In
here, my
Ramayana,
lord,
we have the, what you call, an side story about Kumbhakaran. The Herculean task of waking Kumbhakaran is also documented. It contains a great stotra on how Kumbhakaran was awakened.
yes. No, that is one aspect, but I don't have, my lord, any dispute or anything, my lord. Nobody can object to, my lord, whatever has fallen for your lordship, that, my lord, it has to, they have to give the explanation why they have not made the NIT till now. But then, my lord, so far this order impugned in this writ petition is concerned, my lord, I'll make submission if your lordship permits me, that there is nothing, my lord, wrong in that, my lord.
Yes, please.
Firstly, my lord, 3 parties have submitted application. There is no notice. But 3 parties, because, my lord, we all know that the tender process will take some time. And during that period, my lord, the petitioner also approached the authorities. I approached the authorities. Another party has approached the authorities. But, my lord, I don't know from where page 71 document comes. Because, my lord, that has not been filed before the authorities. From the order itself, my lord, it is clear that there are only 3 parties who have filed the application. There may be some collusion with those parties, my lord, I don't know. But I don't know how, my lord, the petitioner could get a copy of that order, which is not in the record of the,
Page
government.
71. Page number.
This 70, no, that order is 70. The petitioner owes an explanation from where he has got this. The authorities say, my lord, my learned friend has made a submission, this is not on record. The impugned order also says this is not on record. This is a document, my lord, submitted by one party, not very clear.
Dhorital Fishermen Cooperative Society Limited.
Dhirbil, my lord.
Dhirbil.
Yes.
Fishermen Cooperative Society Limited.
Yes, that is not clear, but then, my lord, they offer 7,000 rupees. There is no receipt.
Okay.
From where, my lord, the petitioner could get this order, this application, my lord, when it is not with the authorities. Petitioner owes an explanation to that. Now, so far as the rates that has been submitted by the petitioner is concerned, rejection of the petitioner, your lordship will kindly come at page 58. The society has offered to run it on daily basis. Has your lordship got it? Page 58, my lord. Messrs. Geramari, GP MSS Limited.
Yes.
The society has offered to run it on daily basis at any rate fixed by the settlement authority. So it has not quoted any rate as such, leaving it to the authorities. Now, my lord, I put this question to myself. If this is left to the authorities, that you fix a rate, while my lord others, for example, my client has offered a particular rate, this will give my lord arbitrariness, a power to the exercise its arbitrariness in my lord settling the, whether on day-to-day basis or otherwise. Because if you do not give any particular rate, if you leave it to the my lord authorities, authorities may consider the other rates and offer it at a better rate than the others to him. I offer 6,937. It will be given at 38. Can that arbitrariness be given to the my lord authorities?
No, you see, these are all permutation combinations. They are all left to the what you call imagination. What would happen? Now let us say, why did the government did not test him by saying 10,000 rupees?
No, my lord. Then it has to be open auction.
That's what
the open auction can be, my lord.
that is what the idea is. You
Yes.
see, you in your case, earlier matter, which is at page 71. You see, that was the idea, because if you are deprived, you put yourself into this parlor. If you come to this cubicle, then you'll understand once you're deprived, then you're ready to make an offer. And you are making an offer, what suits you best?
That is, my lord, what we have done.
No, it's okay.
My client has
No,
done.
I'm just saying,
Yes.
mentally, if you come to this cubicle,
My lord.
then you'll find that when you are here, when you are aggrieved.
Yes.
So once you are aggrieved, you are making an offer.
Yes.
Now the question is that it's the same issue which I said earlier, that what could be the tenure? You see, once a day-to-day basis settlement is going on, there are a lot of litigations which are multiplying. You are agreed once, Das is agreed, next somebody else will come. Now this litigations will go on. Now the question is, for a daily settlement, there must be some criteria to be laid down by the government.
True.
So that there is no arbitrariness, because once you say, you gave an example that, okay, I quoted 6891. So arbitrariness would be, they will give it to 6892.
Yes.
Correct. That's an arbitration, arbitrariness. So how can this be checked?
My lord, had the parties offered, my lord, a specific amount, each and every party, my lord, the base offer would have been accepted. And this is for a very limited period of time. Very limited period of
5
time.
years is not limited.
Not 5 years, my lord. Till the, my lord, because otherwise also the government is bound to issue the NIT. Is bound to issue the NIT, and they have made this, my lord, temporary arrangement till it is finalized, so that, my lord, it gets some revenue. My lord, I don't think there is anything wrong in that, my lord, in the government earning the revenue and giving to the party, my lord, who has offered the highest. And second ground, my lord, my learned friend was harping on. From the records submitted with the application, it appears that the society has been settled with 160% government fishery, namely so and so. This is not a ground of rejection. If your lordship kindly sees his application, it is his statement, my lord, he was saying. Your lordship will see his application. Page 52. That is his application before the commissioner. Paragraph 3. second paragraph. That, sir, your esteem office passed an order of temporary settlement for the fishery group number 288 Dhanar Brahmaputra on daily basis to so and so. And no, they stated, my lord, it is settled with them. No, it to Garamari, not Tahatok dear to question. Yes, first paragraph, my lord. With most respect and humble submission, I understand begs to state that Garamari Gaon Panchayat so-and-so is a registered bona fide fishery cooperative society of 100% scheduled caste fishermen. Your esteemed office has given settlement of group number 187 Dhanar Brahmaputra and Sataguri to our Mrs. Garamari GP. That is his statement. And that has only been stated here, my lord. That is not a ground of rejection. Your lordship will kindly read again, my lord, page 58. From the record submitted with the application, it appears that the society has been settled with 60% government fishery number so-and-so on regular basis, which is adjacent to the fishery. So that is, my lord, he wanted to make it to his advantage because it is adjacent. And therefore, this was stated. This was not a ground of rejection. The ground of rejection are two, my lord. One is that the society has not submitted any other document except the IT challan, and that, my lord, it has not offered anything, any specific amount. The society, first line, the society has offered to eat on daily basis at any rate fixed by it. So, my lord, without a specific rate, my lord, how can the government decide to whom it has to be given? So that arbitrariness cannot be bestowed upon the, my lord, government by saying that, my lord, you offer whatever price you give, will accept that. Therefore, my lord, in my humble submission, there is, my lord, nothing illegal in this order. This is transparent. And so far as the, my lord, your lordship's order judgment, my learned friend was referring to, that is at page 71. The facts in that case, my lord, does not come in here because there, my lord, there only one party asked for extension. And your lordship has said that, my lord, there has to be notice, there should be other parties should be considered. So, my lord, your lordship judgment at page 72, my lord, that does not fit into our case. Our case, my lord, there are three parties who have, knowing fully well that the settlement, regular settlement will take some time, three parties have approached the authorities. And the authorities have settled it in favor of the best offer. And here, my lord, the case was that, my lord, that one particular party was asking for extension. Your lordship has said that it has to be, my lord, notified so that others can participate. So, my lord, this ratio of this case does not fit into our case at hand now. Therefore, my humble submission before lordship is that, my lord, leaving aside the compliance and of the Honorable Supreme Court's direction and the undertaking given by the authorities before the Supreme Court, my lord, I will not submit anything on that. But then, my lord, in whatever way it proceeds, it will take some time. Even if your lordship directs that the NIT should be issued tomorrow, even then, my lord, it will take some time. And during this period, my lord, there is no reason why the government should be deprived of the revenue when it has been given to the, my lord, the best offer in a very transparent manner. This is my submission.
I'll just give a reply. Just one
Yes,
second.
no, let him complete.
Yes.
Mr. Sharma.
Yes.
This Supreme Court order is of different fishery, lordship.
Then why you mentioned here in your
It is not of this fishery, lordship. This is the this is of Dibrugarh district, lordship. This is not of this fishery, lordship.
No, but if it is not there, why should it be made a part of your instructions? Why you made us waste our time, find out the internet?
Lordship,
I have checked up. I gave it to my second court master. He spent time.
Lordship, the reason is that giving reference to this order, lordship, the reason is that here, lordship, the Supreme Court has said, considering the facts and circumstances of the case, it is directed the petitioner may be permitted to continue on day to day as per the terms already decided. this order, this line should be, these lines for reference of these lines here, lordship, here in this case, lordship, peculiar case, in this stated case, lordship, the after disposing of the case from the division bench, lordship, there we have to go for fresh tender, lordship, fresh NIT, lordship. On that part, our contention, our assertion is this reference of this case is that we can go for daily basis. The Supreme Court has said we can go for daily basis till tender process is over. Lordship, here we can give an assurance, lordship, within 10 days or 15 days from the MCC over, we will issue the NIT. That assurance, lordship may take.
You will issue it, now you complete the process after the model code of conduct.
Lordship,
Calling of tender is not banned.
Yes, true. They can, my lord, issue immediately.
lordship, we can, lordship, it permits,
because
lordship,
you
we
see,
can go for.
If you say that, we just have to go to the bar and get a newspaper, Assam Tribune today's.
Lordship.
In Assam Tribune, if there is no tender today, we stop that process. But if any tender by any government is either state government or central government is found there, then you can't take a plea that in model.
Lordship, lordship can direct us. We will go for it.
And if I don't direct, it will not go.
Lordship, there is a trend, lordship. Here, lordship.
No. You see, are you abrogating your governmental decision to the court? Are you relinquishing everything? You are saying that all decision till 7th shall be taken by the court. So you see, whenever it suits you, you take a decision.
No. Lordship, as per my instruction, lordship, they are not issuing tender nowadays. Even our fishery department in AFDC also, in corporation, we are not issuing tender nowadays.
No, that's okay.
Nowadays, in fishery department, they are not issuing tender because DC is involved. Lordship.
Everywhere,
The meta is here.
everywhere you have a arrangement like this, daily settlement.
No. We are
Then?
in a corporation. We do not go for daily. There is a full man judgment. In there is a separate setup in corporation. Here, lordship. Here this reference, lordship. Lordship may record my statement. Lordship will go for immediately 15 days. Or lordship may it permit, lordship. We can go for issuance of tender even after 2-3 days also, lordship. We can direct DC to.
But better do it. You can step out, give a phone call to your authorities and come back within 5 minutes.
Yes.
If they are ready and willing to do it, no sarcastic comment from the court.
That's right.
Those inquiries and all.
2 minutes, lordship.
No, 5 minutes, because then we don't pass any sarcastic comments. No vigilance inquiry.
Save yourself.
So you take 5 minutes.
Lordship.
You take 5 minutes. In the meantime, just see few things.
That would be your lordship has asked what is the way out. That's
Yes.
what your lordship has said. What is the way out? The way out is there because my learned friend once appeared for Suresha and his whole case was that there should be a regular settlement. My case today also, forget about 8,000 also, my case is regular settlement. Then what is the way out? Then what happened? Then whatever it prevailed at page 56, kindly see page 56. 56. Kindly see page 56, that's a order. Kindly see before the paragraph, last paragraph, in persons of, see the whole order. It has withdrawn in immediate effect running of daily basis order issued in favor of so and so, date of Fishery Department in the light of the order passed by Honorable High Court in a combined judgment in so and so, which was upheld the same order passed by the Honorable Division, and government also instructed to take over the possession of fishery by keeping it as a khas until further orders. Now, in view of the above instruction as well as the order passed by so and so, in respect of fishery orders under deemed to have taken from the said lessee with immediate effect, and it is directed none will be to operate fishery in the said government fishery until further was issued from the government. So if they have taken, it is a khas on the ground that they will float a regular settlement tender. So let it keep kept as a khas. So whatever the view which my learned friend APF suggested, let it prevail. I am also today saying let it prevail. My learned friend should not be concerned about the revenue part. The government will say what is revenue. They will be bothered about the revenue part. The revenue the government should lose, government should not lose. He is same like me only. And he, my lord, in Suresh, my learned friend saying the regular settlement. And today also, if the order of 56 way out is let it go back to the government as kept in the khas position. They will run and they will make the NIT my immediately regular settlement. Immediately regular settlement will be made. And this way, till a regular settlement is made, this from 2012 it is continuing. 2019 it is continuing. So let this order prevail, that is khas position, it goes back to the government.
Where will we find the power of tendering in this Assam fishery rules?
12, rule 12. Rule 12.
Well, I'll just add one sentence to my learned friend. Yeah, my learned friend is relying on page 56. 56 is an order of the deputy commissioner, who says that it be cast till the my lord government takes a decision. On the same day, government takes the decision that it should be NIT should be issued, and in the meantime, my lord, this order has been settled. Therefore, he cannot, my lord, just say that let it be as stated in page 56, ignoring, my lord, what is there in page 57. Rule 12, my lord. And my lord, rules do not say anything about, my lord, daily settlement. But the rules also, my lord, do not prohibit a regular settlement.
For a moment, my lord, can I just take a leave of this?
Basically, justify the details. You can justify it.
Lordship. May I, Lordship?
Just.
Election code of conduct violence নহলে মই কৰি দিলো পেন্সিলে ডাইৰেকশন ডাইৰেকশনে দিব লাগে সেটেলমেন্ট হলে দিবা
I'll just take a break and come back. Yes, you wanted to say something?
I have talked with the English committee and advised that actually they are scared about moral violation of moral conduct, code of conduct. As an officer, Lordship, they have nothing elaborate. Lordship, they will direct to the DC. Our process is that we direct DC to initiate tender. We will immediately issue order within 3 days after.
Okay, I'll just take a break and come back. Yes, Mr. Sharma. There's something for you. Does he? Can you find out which model code of conduct prohibits tendering process?
It's going on, Lordship.
No, that's okay.
But
No, you see-
actually DC is involved in election matter.
No, that's another point. But the question is model
There
code
may
of
be
conduct.
misconception among the officers also, Lordship. That
No, that's okay.
I advise
I'm just
them.
trying to understand.
I have advised them, they said that, okay, we'll go tomorrow itself,
Let
they
me
will
understand.
issue order. Tomorrow.
It does not prohibit.
It doesn't prohibit. And this is from website of Election Commission of India.
But there is a.
No, you see, what is the general perception, I don't know. But the model code of conduct, if you are making a statement, then we are showing it to you that model code of conduct does not prohibit tender. It only says that you will not give those incentives, that all these freebies during the time of elections. That is the only prohibition. So, and you will not give assurances of the political people will not give assurances of making roads, giving water connection. And the if you can read it for tenders, I don't know. It says. Make any ad hoc appointment in government public undertaking which may have the effect of influencing the voters in favor of the party in power. That is the only prohibition. No ad hoc appointment. So therefore, it is ask your officers not to be in a misconception about model code of conduct.
Also in other department also.
Okay. Now a question to you. This no, not to you. You see, I am told here that the fishery tenders are as per Rule 12. Please come to Rule 12. You have a book. Except those referred to in sub-rule number 8B, all registered fisheries shall be settled under tender system of sale in place of sale auction, provided that the government shall settle a 60% fishery category fishery, a special category of cooperative societies, non so and so in the neighborhood by tender system. Now there's an explanation. For the purpose of this rule, the word special category means includes the cooperative society so and so. Correct. So therefore, where does this daily settlement fit in? And number two, supposing assuming that you do it for a temporary arrangement, have you brought out any executive instructions which is required to be followed? Because you see, Mr. Chaudhary has raised the issue that there should be no arbitrariness. So in the absence of rules, there would be scope for arbitrariness. So now if you want to extend it, you have to inform people that you want to do it. If you are afraid of model code of conduct, will on and from 10th, this daily settlement must stop. And if you want to give it further, then it has to be notified and then participation has to be done. Till 10th, we are not disturbing Mr. Chaudhary. But on expiry of 10th, on 11th, this ad hoc arrangement will not continue.
Lordship, we will also, I advise them to go for tender, issuing tender tomorrow itself.
No, that's okay. I'm not saying now, since you see, your officers are merely government servants, they are afraid. We are not taxing them right now. Till 10th, they are at freedom. But on 11th, there should not be any daily basis settlement unless you have executive instructions made by them. In the entire fishery, this daily system would stop on and from 11th. And if you bring out a transparent policy, notify it or give wide publicity so that anybody can participate in the tender in that system. Nobody will say that I leave it to the government. Mr. Chaudhary's anxiety that 6891 may become 6892. Those things has to be taken care of.
I will advise them not to.
We are We are not closing this matter. We are just issuing a notice. And there will be a direction, and then we list it on 13th of May. And you will inform us what is happening. Mr. D. Das, Senior Counsel, assisted by Ms. E. Talukdar, Counsel for the petitioner. Also heard Mr. P. Sharma, Leonard, Standing Counsel for the Fishery Department, representing respondent numbers 1 and 2, and Mr. M. Shetial, and Government Advocate, appearing for respondent number 3, 4, and 5, as well as Mr. M. K. Chaudhary, Leonard, Senior Counsel, assisted by Mr. DJ Medhi, Leonard Counsel for the respondent number 6. Next paragraph. The petitioner claims to be a registered cooperative society under the Assam Cooperative Societies Act of 1945. And it is projected that the society of the petitioner is consists of 100% actual fishermen belonging to scheduled caste community. It is the case of the petitioner is that pursuant to the last NIT issued on 15/11/2019, the group number 2/88 Dharnad, DHARNAD, Brahmaputra, Part Roman 2 and 3, Fishery of Dhubri district, was settled with Messrs. Chanda Khola, CHANDA KHOLA, Bill Fishery Cooperative Society Limited, for the period 2019-20 to 2025-26. No. This did not happen. This tender did not happen. 2019 tender was
Not given. After 2019, my lord, who tender has been?
No, you see, I'm looking at the synopsis of this writ petition. First line says that it was, NIT was issued for 2019-20 to 25-26. So that means if this 25-26 is still going, it's not yet complete. So therefore, 2019 tender did not happen.
Did not happen. Did not happen, Doctor.
It was
2019 tender was not given effect to.
not given effect.
Not.
Okay. First of how stop for you. It was issued for the period 2019-20 to 2025-26. First of however, the said tender was not given effect to, as one Messrs. Chanda Khola Bill Fishery Cooperative Society Limited had preferred a writ petition seeking direction upon the respondent authorities for granting extension of lease for a period of 2 years and not to give effect to the NIT dated 15/11/2019. Full stop. This could, by an interim order dated 16/12/2019, passed in WPC, 8310/2019 passed a common order dated 12/2/2024 along with WPC 8281 of 2022 by directing the respondent authorities to what is this one so? Goes this head. WPC 8310 of 2019 has withdrawn. So, however, the connected WPC 8281 of 2020 was allowed by setting aside the order dated 23/12/2019 issued by the Deputy Secretary to the Government of Assam of the Fishery Department. Full stop. But it may be mentioned that by order dated 23/12/2019, the respondent authorities had allowed Mrs. Chandrakula Beal Fishery Cooperative Society Limited to operate the fishery on daily basis. The petitioner in WPC 8281 of 2022 referred another red petition, which was registered as WPC he said strike that out. This could have further ordered that keeping in view the fact that the interest of public exchequer will be best served if a new tender notice is issued by the state respondents and a fresh settlement of the fishery is made, which should be commensurate with the prevailing market rates. And accordingly, the state respondents were given liberty to initiate a fresh tender notice for settlement of fishery. Full stop. In the meanwhile, the appeal filed by the said Chandrakula Bill Fishery Cooperative Society Limited, being WA 58 of 2024, was dismissed by order dated 28 to 2024. In the meanwhile, the respondent authorities, specifically the respondent number who has passed this order, settlement order is 8 March. The additional secretary to the government of Assam Fishery Department has issued an order dated order number small e capital CF number you will find it page 57 dated 8/3/2024, amongst others settling the Dharnad 2/88 Dharnad Brahmaputra Part 2 and 3 fishery of Dhubi district to the respondent number 6 society, namely Mrs. Dharnad Brahmaputra Fishery Cooperative Society Limited. At their offered rate of ₹6,932 per day. The set settlement order on daily basis is the subject matter of challenge in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. From the just say issue notice returnable on 13/5/2024. Requisite extra copies of the writ petition to serve on the Learned State and Departmental Council in course of the day. Next, heard both sides on the prayer for an interim relief. While the Learned Senior Counsel for the petitioner contends that he had given that the petitioner had given an offer of agreeing to settlement at whatever rate is fixed by the government. It was projected that projected from Annexure 13 to the petition that another cooperative society had given an offer of rupees 7,000 per day for the said fishery. And it is stated that the settlement was on daily basis was made without adopting any criteria. For contra, the Learned Standing Counsel for the Fisheries Department has submitted that the Fishery Department has decided to issue a tender for settlement of the said fishery in accordance with Rule 12 of the Assam Fishery Rules, 1953. Most of it is however submitted that going to the Lok Sabha elections, which is due in the state of Assam, and we should conclude on 7/5/2024 The respondent authorities could not issue a tender owing to the election code of conduct. So it is submitted that the receipt of an 13 representation is disputed. It is disputed and denied, as he has instructions that no such representation was made to the respondent authorities. So it is also submitted that the petitioner had not quoted any rates. And no documents were submitted. And therefore, a vague proposal of the petitioner could not be considered. Next, by contract from the learned senior counsel for the respondent number 6 has also submitted that in the interest of revenue, as the rate quoted by the petitioner was highest among the other participants, the said ad hoc arrangement may continue till the new tender is floated. Next now. From the facts which emerge in this petition, it is noted that the previous settlement of the fishery by way of tender took place in the year 2012-13. It will not be 12-13, it will be 11-12. 7 years, 11-12 will end on 19.
2010 and 2012 settlement order has been passed.
Okay,
For a period.
The previous settlement orders in course of tender process was issued sometime in the year 2012, which is gathered from the last NIT issued on 15/11/2019, taking into account the settlement period of 7 years officially. Full stop. Therefore, the ad hoc arrangement is found to have continued in the fishery in question from 2019 till date, which is more than 4.5 years now. Next paragraph. There's no dispute in the bar that the process tender system is envisaged under Rule 12 of the Assam Fishery Rules, 1953, which is quoted below. From the above provision, it appears that there is no scope for a daily settlement of fishery, as the positive prescription of the Rule 12 is that all registered fisheries shall be settled under tender system. Next, therefore, this is high time that the state government should formulate a policy as to how this daily settlement should be, if at all done, should be handled by the competent authorities. Full stop. When the positive prescription of Rule 12 is only to adopt tendering system, the daily settlement frustrates the very purpose of Rule 12. Next, therefore, taking note of the apprehension of the authorities of the Fishery Department, expressed through their then standing council that there is a model code of conduct which prohibits them from resorting to tendering system, notwithstanding that from the website of the Election Commission of India, the court does not find that the model code of conduct affects the regular tendering system. Nonetheless, taking note of the apprehension of the respondent authorities, the court is inclined to provide that the interim arrangement of daily settlement as per the in the present case in favor of respondent 7-6 should come to an end on 10/5/2024. Full stop. Next, it is further provided that in the event tender processes it cannot be completed within 10/5/2024, in that event, if ad hoc arrangement of daily settlement is made, the respondents specifically the Commissioner Secretary to the Government of Assam, Fishery Department, shall, in respect of the present fishery in question, issue a guideline to be followed for having a daily settlement of the fishery in question, and thereafter take a decision to have such guideline for the entire state of Assam for all in respect of all the fisheries covered by the Assam Fishery Rules, 1953. Next para. The process of daily, the process of putting the tender on daily basis shall be notified in the Dhubri district so as to enable all the fishery in this area to participate in the process. Next para. In the event the tendering process is not initiated or cannot be brought to its logical conclusion within 1 month from 10/5/2024, on and from 10/6/2024, there would be no daily settlement, and the fishing activity, the present fishery on ad hoc basis should come to an end. And no fisheries shall be, and the present fishery shall not be operated except as provided under section Rule 12 of the Assam Fishery Rules, 1953. Next para. It is made clear, next para, it's made clear that as the court does not find the model code of conduct to come in the way of issuance of tender, the respondent authorities may go ahead with the issuance of tender However, the same shall not be finalized till 10/5/2024.
Finally, it will.
Next paragraph. Affidavit in opposition, if any, be filed at least 2 days prior to the next date of listing, list on 13/5/2024. Mr. Das, we are, right now we are declining the relief.
Yes.
But till 10/4, we continue with the same arrangement. Till 10/10/5.
Highly obliged.
My lord, although it may not be the right place to say, my lord, since it's an interim order. Otherwise, my lord, if it is a final order, we could report, my lord, without taking permission. Can we report it, my lord?
Pardon me?
Can we report it in the, my lord, Law Journal, although it's an interim order? Because your lordship's observations are important. No?
Yes, Lord.
And
Okay,
the
I'll make it, I'll permit that.
my lord, all right.
Highly obliged.
I don't know if it is right or wrong, it has to be
Yeah,
tested,
many
but
things, Lord.
this
Regarding
this
MPC.
temporary basis is, what you call this, creating a problem whenever we take up this bench for.
And also, my lord, the code of conduct, that your lordship observation, that will be helpful. In our case.
This will help
Okay,
for
but-
all department lordship.
But on that,
But I think the appropriate order, not this case, would have been, they should call for the respective interested party in the board and they should give an offer. That will be the best. I
we
feel.
leave it to the government, we say
No,
that
that's-
the government will formulate a
Otherwise,
policy.
no, what will happen? What will happen in this particular case? They could have done it. You
No,
cannot.
there's a problem, Mr. Das. You come to rule 12. You come to rule 12. I had that considered, but rule 12. Fishery shall be settled in a tender system in place of sale auction.
Yes.
So sale auction means that table bidding cannot happen. So I took into consideration, I was reading it carefully where you were not there. I was reading it carefully, but I found that this system is contrary to the rules. Therefore, I could not do anything.
My lord, but then if it is contrary to that sale auction, it is like calling it is a say auction type only. You are calling someone making an application. It's like an auction only.
No, it's
Someone
making an
someone
No, but
giving
that-
an
no,
offer.
No, but that amounts to a tender process. You see,
Yes, yes.
I have considered that, Mr. Das, please explain if I'm incorrect in understanding. You see, once even daily basis is given, public are given an offer on daily basis system. XYZ quotes their rates. It may be 1 rupee, 2 rupee, or 3 rupee. They are quoting some rates. It almost amounts to something like an auction. But if we permit, what do you call this, bidding in front of the officers, then it becomes, which is prohibited here, it becomes a auction, sale auction. So therefore, I did consider that. And therefore, I had to couch my language.
No, that's no problem, my lord. But that arrangement only should be to a point. It's not that they can continue.
That is stopping on 10th.
10th of
April,
May. Beyond that, there will be no
Because they are
extension.
afraid we are not taxing them because the officers are really afraid.
They are afraid and they will also be busy in elections. Then there are two.
Yes, we understand that.
But they will not go, but they cannot give an extension again that this is
Not
happening
give
and we'll go for
That we
extension.
are prohibited.
Yes, they will not go for extension.
See now.
Obliged.
But we will make that because it will make to be a good affair.
Highly obliged.
Deeply obliged.
And I'm sorry, those remarks were made because I took this, what you call this, instructions to be the starting point.
Yes, that was a little, my lord, instruction is a little, my lord, wrong in fact.
Wrong instruction.
No, not wrong.
Wrong in the
You see,
sense that, my lord,
I have a habit of hearing this much and understanding this much. So
your lordship
therefore-
is very meticulous, my lord.
No, because when it came, I just checked up the net. I found that order. Then I told my court master to print out that. So therefore, I was carried away because when you give a undertaking before the Supreme Court,
Yes.
But that daily settlement, my lord, daily, that should go. My learned friend will be on this side, I'll be other side, taking the advantage this way, that way. So whatever
that
may
is-
be, whatever may be,
that is all we
definitely.
can say happy fishing.
If fishing is stopped, then it's a real problem for me. I don't know what about my learned friends. Particular.
Item 3.
Yes, Mr. Datta. Okay, now, Mr. R.K. Datta, counsel to the petitioner, the claiming non-payment of outstanding dues of rupees 61,09, 526 out of total supply bill of rupees 99,79,887. The present petition has been filed under Article 226 of the Constitution. Notice, you are accepting notice
Respondent 1 and 3.
for respondent number 1 and 3. I'm sorry, I'm still again forget your name.
Tushi Sinla.
Tushi?
Sinla.
Tushi Senla. Last one. Please write it down. Huh? Give to the command. You keep this name. Okay, she is noted in. For 1 and 3. The next notice for 1 and 3. You requested extra copies of the petition we served on in course of the day. Finance will be there. This G. Hazarika. This G. Hazarika, Leonard standing counsel for. She's for finance or Mr. Gogoi? Who is B. Gogoi? Mr. B. Gogoi, standing counsel for finance department.
Lordship for respondent for notice making.
So we can accept notice for the respondent. Extra copies from course of the day. The petitioner shall take steps within 2 days for servicing notice on respondent number 4 by registered post with DD. Next, dependency of the petition should not be a bar for the respondent authorities to examine the claim of the petitioner to release it. Mr. Chalia, you are there? Mr. A. Chalia, parents department. Okay. This one, list after 4 weeks. Okay. Item 4.
In this case, I'm open for the petitioner. By last order, I was directed to take steps on respondent number 5.
Yes.
Also, due to some misunderstanding, we could not take allow 2 days time. Like take first step.
Okay. On the prayer made by Mr. S.C. Kayal and counsel for the petitioner, 2 days time is granted to take steps for service of notice on respondent number
5.
The notice is made returnable on so and so, just accordingly.
And see, private the officer respond, they were supposed to file a affidavit.
By registered proceeding, notice is made returnable on so and so. Affidavit by
respondent number 1 to 4. Agriculture University.
Who is for 1 to 4? Government.
Government. Lordship, they have a standing council also.
Pardon me?
Mr. They have a standing councils.
Assam Agriculture University.
Mr. Gogoi was there. Gogoi was there. Before some time, he was here in the court.
His name is there in the cause list?
No, that's. For this, their name is not sound.
Agriculture University, I think, Mr.
Prangam Goswami is the senior standing council.
No, Mr. B. Chaudhary, I think.
No, B. No, now it is changed. Mr. Gogoi was there. He's junior to Mr.
B. Gogoi.
B. Gogoi.
You see, both sides are represented. The affidavit by the state respondents be filed by them.
Much. Okay.
After 5 weeks, registered post steps. Item 7.
Item 7.
This case, my lord, I need some more time, my lord. And for respondent number.
We have your order was dictated. Your file I could not return. I think they will correct it and then give it to
My
you.
lord.
Order is dictated. Yes.
I pray for some time, my lord. After Bihu vacation, my lord.
And for 2 and 4, my lord.
Yes, this matter has become infructuous by now.
Lordship, we have no instructions relating to that from our client. So Lordship, some time may be granted. We can take their instructions.
No, because this appears to be a infructuous matter. Also, it's a represented the counsel for the petitioner as well as the standing counsel for respondent number
2 and 4, my lord.
2 and 4. Therefore, it is for adjournment. There is allowed. Next question. It appears that the contract work was to be completed within 2020. And therefore, an impression is gathered that the matter has become infructuous. The next date, the counsel for the petitioner shall obtain instructions as to whether the matter has become infructuous. Similar instructions shall be obtained also by the learned government advocate and the learned department counsel.
My lord.
List after 4 weeks.
My lord.
Much obliged, Your Lordship.
Yes, item 8.
Item 8.
Yes, Mr. Gogoi. Within what time we are paying?
My lord, here, probably, my lord, my learned friend has, my lord, wrongly represented, my lord. In item 8, she is supposed to appear for higher education, not in 7. My lord. That's why, my lord. My lord, here is a, my lord, issue relating to construction of a college.
Yes.
We have the PWD has constructed, my lord, have supervised the construction as per the, my lord, request of the higher education department. So whatever fund is required, they will have to pay. Only she will have to seek instruction when they will be. They will
Pay
get the
within 3
fund.
months.
One.
This is already a 2020 matter,
Yes, one. Immediately after view petition, my lord.
but your affidavit is not there.
That's right.
When it comes to payment of money, government is not ready to file affidavits.
Take.
Only, my lord, the admissible part, my lord. We'll have the instruction only on that admissible part. Whatever the admissible.
No, you see, 4 years if you don't deny it, so why would
Immediately after.
she suffer? You see how serious she is. No smile at all.
And let it be on 29th, my lord. We'll
29.
come up with something. 29 April.
Okay, also is a represented. One last opportunity is granted to the respondents to obtain instructions and to file affidavit in opposition if so advised. Next, the respondents are put to notice that in the event no affidavit in opposition is filed, the court may invoke the doctrine of non-traverse and pass appropriate orders on the next date. List on 29/4/2024.
That affidavit in opposition or written instruction. Otherwise, my lord, if it is admissible part, lordship can dispose it of with a written also.
Or instructions, well, affidavit or instructions. Okay.
I don't know, earlier matter my. Fix number 7,
I did not write your name. I just
Yes.
said counsel, so let it go. Your name I did not record.
Month.
Item 12.
Wait, please, Your Lordship. Lordship, can you take up this matter after being?
Just a moment. Yes, who's praying for time?
Yes, Lordship.
Why?
Lordship, today there is some difficulty, Lordship. There is some difficulty, Lordship. I see.
What says the representative on the clear made by counsel for the petitioner, the matter stands adjourned today. List after answering view vacations. We continue at 2. This is a meeting.
Last minute request before Lordship either. In the morning, your Lordship has allowed me to move an unlisted motion today. And given the sleep, informing that the number is being supplied shortly, man. But by the time the filing, we have filed it this morning, man. The number was given, and by the time, man, the other slips were already same. So I thought it better to make a mention before Lordship.
You don't read the court master exam.
It's an urgent matter, man.
No, because there is a difficulty coming in. The registry is complaining because of
At least for tomorrow, my lord, some urgency is there, man. Tomorrow morning, my lord, much obliged.
you file your affidavit.
Yes, Lordship.
Yesterday or day before yesterday, on the last date we passed an order. Yesterday, I think we passed an order.
Yes, Lordship. Lordship, in that case, Union of India was a party. But in this case,
No, you see, what will the Union of India do? Did you give the work to the petitioner on the condition that unless the Union of India doesn't pay, you will not pay him? Is that your condition or tender?
Lordship,
So it is between you and the government, how you deal with it. But this payment will have to be released.
Lordship, it can be only be released after the Union of India has been made a party.
That we don't know. It is for you to get the money from the government of India.
Yes, Lordship.
If you can show us that this tender there was a condition that Union of India doesn't pay, you don't get. If that is a condition, you escape.
Lordship, I'll get the instructions for the same and
Which is the representative? The this A Lodha.
A Lodha.
Counsel for the
1, 3, 4, and 5.
Respondent 1, 3, 4, and 5 has submitted that the Union of India is not a party to this petition, and it is submitted that the funds for the tendered work is shared with the ratio of 90:10 between the Union of India and the state government. Which we do not find anything on record to show that the bidder of the dash petitioner was informed that unless the Union of India does not release funds, he would not be getting the contract value. The payment for the contract work. Before comment. We don't find the Union of India to be a necessary party. Just the power command, appeal made by Learned Counsel for respondent number 1, 3,
1, 3, 4, and 5.
4, and 5. Grant an opportunity to the Learned Counsel to satisfy the court on the non-joinder of Union of India as a party. Just after 2 weeks.
I'm appealing for respondent to your lordship.
Is S. Barwa.
RM Barwa.
RM Barwa. Then Counsel for respondent number
2.
Respondent is present. Please start 2 weeks. Next, the dependency of the arbitration shall not be a bar for the respondents to release the contractual bill of the petitioner, if found to Yes.
Item 19,
Oblige, your lordship.
May it please your lordship. This is
Is
petition.
not an arbitrator then?
Lordship, our case is that lordship, page number 65.
65
Yes,
years.
lordship. Clause 64(1)(2).
1, 2 years.
The demand for arbitration shall specify the matter which are in question or subject of the dispute or difference, as also the amount of claim item wise.
Yes.
Only such dispute or differences in respect of which the demand has been made together with counter claim or set off given by the railway shall be referred to arbitration, and other matters shall not be included in the references.
Yes.
So here, lordship, thereafter, this is the one of the arbitration clause, lordship, and by our later dated 15/9/22, we have asked them to submit item wise claim, lordship, which they have not submitted, lordship. Item wise claim amount for sending the matter for arbitration, lordship, which is as per clause 64(1)(2). In that case only, lordship, we will come to know how much the amount will be, because clause 8, there is a bar if the
Where
amount.
is your letter of arbitration?
My lord, it is at page 130, my lord, section 21 reference, my lord. Section 21. Actually, my lord, may I just place one fact, my lord.
Yes.
I understand my learned friend's, my lord, point. Now, what has happened in this case, that contractor, my lord, suffered a sudden termination from the authorities, my lord, which was absolutely arbitrary. He came before this honorable court by way of a writ petition. The honorable court, after observing that there is an arbitration clause, inspired the parties to go for arbitration. When that arbitration, my lord, for going under section 9, my lord, for even for paying my lord, interim measures, some step under the arbitration is always required. So at least section 21 reference should be there, in my understanding, my lord. So section 21 reference, when it was made, the final measurements were not done. Final measurements were done at a much later stage, my lord. So that is why this quantification has become difficult. And about the jurisdiction part, which my learned friend has just now submitted, that my lord, the learned sole arbitrator, if appointed, will have a power to rule on his own jurisdiction. If the jurisdiction is exceeded as per the agreement.
But if the requirement of the act is that you should, if
Section-
your agreement is that you will give all the claims. How it can be waived because you are bound by the agreement?
And this 64(1)(2) has a effect of clause 8 also, lord.
My lord, here, my lord, our basic challenge will be, my lord, that the termination itself. The other claims will be consequential. If the termination is held to be illegal, my lord, other claims under section 73 of the Indian Contract Act will come into play, my lord.
You see, that will be adjudicated only when you challenge this clause. Now, as on today, this clause remains as a part of your agreement. If the requirement is to follow it, you'll have to follow that.
My lord,
And your waiver of clauses in the agreement.
my lord, their main clause is, my lord, which they want to have is, my lord, if you're also peruses page 67, my lord.
Clause 8.
Clause 8, my lord.
Because
This is
clause,
what creating difficulty for them, my lord. I have a submission to make in respect of this. If your lordship peruses clause 8 for once, my lord.
Yes.
I'm just reading it out. The provision of clause 63 and 64 of the to the general conditions of contract will be applicable only for settlement of claims or disputes between the parties for values less than or equal to 20% of the value of the contract. And when the claims of the disputes are value more than 20% of the value of the contract, provisions of 63 and 64 and other relevant clauses of the general conditions of the contract will not be applicable, and the arbitration will not be a remedy for settlement of such disputes. So, my lord, this creates a jurisdiction for the arbitrator. If my claims go beyond 20% of the contract value, my lord, then the arbitrator will cease to have jurisdiction. In my respectful submission, that power has already been conferred upon the arbitrator by the Act itself. The section 6, as per section 16 of the Act, the arbitrator can rule on his own jurisdiction. If I lay some claims before the arbitrator which exceeds 20%, decidedly they will raise this objection and arbitrator will deal with the jurisdiction of part, my lord. My difficulty is that when the termination was given effect to, well, I have to challenge the termination, otherwise I will be remedialized. May I just read section 16 of the My Lord Act?
You see, you take a risk. Clause 64.1.2. It says that only that part for which demand of arbitration is made will be there and others will not be included. So if you don't quantify, then the prohibition clause.
My lord, respectful submission is that the consensus between the parties was primarily to refer the disputes to arbitration pursuant to section 7 of the Act. There is an arbitration agreement is there.
No. Once you have this agreement executed, then you are bound by this agreement. What is your intention? So far as civil side is concerned, is preponderance of probability. It's not what you call the interpretation as done in criminal law.
But my lord, that factum of termination now, that since it has happened and I want to challenge it, now appropriate forum will be only.
But if you see, you can have only one way out. 64.1.1, 64.1.2.
No, sir.
So it cannot be left open for the arbitrator to decide what will be his jurisdiction. The court, when appointing an arbitrator, must give a broad, what you call there should be some observation as to what would be the reference, because otherwise the arbitrator would say that there's no, the court did not take into consideration 64.1.2, and therefore the scope of arbitration is fully open. Because we give an order, we appoint an arbitrator, but we'll have to make reference to 64.1 and 64.1.2 and say that the arbitrator will be bound by this. So you take a call.
My lord, so far as 64.1.2 is concerned, my lord, it says that arbitration proceedings shall be assured to have commenced from the day a written and valid demand for arbitration is received by the railways. That is in consonance with section.
It's not complete.
The claimant shall submit his claim stating the facts supporting the claim along with the relevant documents. Well, that is my case, my lord. When I made the reference under section 21, my lord, my reference has not been rejected, my lord.
It is still not complete.
My lord, the claim, I'm again reading that. The claimant shall submit his claim stating the facts supporting the claims along with all relevant documents and the relief or remedy sought against each claim within a period of 30 days from the date of appointment.
Which provision?
My lord, this is, I'm reading clause 64.1.2a, my lord.
No, come to 2 first, then A will come later on.
Okay. The demand for arbitration shall specify the matters which are in question or subject of dispute or difference, as also the amount of claim, as also the amount. My lord, my main dispute that still remains that my termination was illegal. Here is a situation where they were envisaging.
Again, same thing, Mr. Rahul. Please read the entire thing.
Only such disputes or differences in respect of which the demand has been made, together with counterclaims or set off, it is their part now, by the railways shall be referred to arbitration and no other matters not be included in the reference, my lord. Now,
you take a choice, you want this or you don't want this. We are appointing an arbitrator, but they'll be bound by 64.1.1 and 1.2. You take a call. Whether you say yes or no, it's your call.
No, If termination survives, my lord, if the termination is decided in my favor, my lord, then as per section 73 of the Indian Contract Act.
No, you see, we are not deciding the issue.
Lordship, true.
Therefore, it's not relevant.
Lordship.
The issue is that whether you are agreeable to this performance of clause 64.1.1 and 64.1.2. If that is okay, we are appointing an arbitrator.
Lordship may appoint, then we'll see.
One thing is that lordship, then also 8 lordship, because it should not be more than 20%.
You see, there he is bound by this. The arbitrator will take note of that.
Lordship, true, my lord.
We are making clear that it will not be what you call any claim. It should be within the bounds of. They will take note of the claim within the bounds of 64.1.1, 64.1.2, and 8.
With arbitrator, it wasn't.
You want you just say a name. You want that former judge or district judge?
Former judge, my lord.
Former judge.
District judge, any lordship file suitable, my lord.
Arbitrator police station, right? Size.
Can it be Justice P.K. Soikia, my lord? He is.
Reporting Honorable Justice C.R. Sharma. But Mr. G. Rahul and counsel for the petitioner, as well as Ms. B. Sharma and CEC appearing for the respondents. So there's again a problem. You have to correct it in the registration, then again it will have to come back.
Yes, lordship,
This is-
consent.
No, this is an application under 11.5. We can entertain applications under 11.6. You make corrections and then it will come again. 11.5 is consensus. This is not a consensus application. So registry shall have to be corrected. This this application under 11.5 of the Arbitration and Conciliation Act 1996 be accepted as an application under the section 11 within bracket 6 of the Arbitration and Conciliation Act 1996. The necessary correction in the constitution shall be done by the learned counsel for the petitioner in the section. Does it? This is which section arbitration?
11.
Contempt section. We put the AOJ in the concerns section, and thereafter they would list the matter again before the court. After making necessary correction in the central registry. I'm told it is contempt section, but I'm not aware. Just try to find out. You'll have to get correction. They'll have to correct the central registry and it will come back. As and when such correction is made.
Obliged.
20.
Your Lordship, I pray for some more time to file my affidavit. Here the issue is also 64 plus 64 of the.
But you've
request.
taken a lot of adjournments. 3 or 4 adjournments you've
Yes,
already
sir,
taken.
Lordship, but I have received the instruction lately, Lordship.
You received it.
Newly received, Lordship.
Okay, both sides are represented. Mr. S.S. Royal and CEC appearing for the respondents has submitted that he has received instructions. And please for is granted 3 weeks time to file a affidavit in opposition to the matter. He will complete after 3 weeks. After 3 weeks, give a date.
May. 13th of May.
Yes, 21 and 22.
Not in these two matters, the claims will be assisting your lordship for the public respondent number 8. But today is out of station, you also need to file a counter.
You have informed Mr. Bhattacharya. Mr. Bhattacharya.
Yes, my lord, in this matter, there has been no stay order, but the order say that it will be subject to the result of the case. Now, my lord, already though that order was there, government has already awarded the contract. So, my lord, it has to be hard. They have already started work. The order awarding the contract to the other party.
No, but once our council is saying that it's out of station,
my lord,
when the prayer is being made that the senior council is out of station.
No, it's all right, my lord. Kindly give me 2 minutes. Sir.
Yes, yes.
Let him take time. Only thing, my lord, they have already taken time twice. So today it has come for admission and all. Your lordship may fix it for vacation. Meanwhile, they will file the affidavit.
Affidavit reply is already filed by you.
Affidavit in
The
the-
affidavit is.
We have filed. They have to file it.
They have to, respondent number 8, but the private respondent will have to file, madam. But the government NBCC has filed.
We have filed it to.
Madam, one they have filed.
And they will have to file 7 and 8. He is representing 7 and 8.
No. You see, till now the prayer for filing has not come. So why should I take on record the prayer which is not even there?
Yes. That's your law.
If he makes a prayer, then we'll consider. If he doesn't make a prayer, then why should we consider that prayer? That means he's waived his right for affidavit.
So the matter will file out.
But give a fixed date. Within 2 weeks, you file it.
Yes.
So we are fixing it for, you want to, if the affidavit is filed, you would like to file your reply also?
So we will reply within 2 to 3 days.
2 to 3 days. Okay. This is,
2 weeks will be, my lord, little bigger in the context. 10 days.
because I am told that he doesn't work on a view holiday.
Lawyers have no time.
I don't know. I don't know personal knowledge, but I am told.
Yes.
It's
Absolutely correct.
One cannot say that. If death sentence come, what you will do? Man will be allowed to be hanged.
No, but this incidentally, death sentence, we don't hear it immediately after vacation.
Learned respected senior is so harsh. He's
No,
giving
but
us
my
death
petition
sentence.
may not be influenced by this process.
It's okay.
That is what
We
I.
accept your statement. And Mr. U.K. Bhattacharya, and counsel for the Bhattacharya and counsel for the petitioners. He has reiterated that there's some urgency in the matter as there's no stay order operating. Next one. Mr. 8, counsel for respondent number 8. Submits that affidavit in opposition has already been filed and as well as reply affidavit by the petitioner.
My affidavit for respondent number 1 to 6.
Oh, 1 to 6. I'm sorry. Respondent 156 has been filed, against which affidavit reply has also been filed by the petitioner. Mr. What do you call, you are appearing for?
In WBC 434 of 24, I am appearing for respondent number 8.
No, one by one. This is first is 434.
Yes.
You are for?
Respondent number 8.
Respondent number 8. Okay. Mr. J. Patwari, Learned Counsel for respondent number 8. Raised for is granted time till 2/04/2024 to file affidavit in opposition in the matter. Full stop. Reply, if any, by the petitioner shall be filed within when?
By 4 days thereafter.
Okay. Within 25/4/2024. Who's appearing for the other respondents? Is respondent number 7 is there?
I am appearing for respondent number 8 only. I think.
What about respondent number 7?
This is a private respondent, my lord. Notice has been issued, and the award has not been given to this party, my lord, actually. So they have more or less not
But what about service report?
service report, my lord.
Have you served on respondent number 7?
Yes.
Where is that? No, notice on 7 is not even issued. Mr. Bhattacharya? No steps.
No notice was issued to serve.
No steps was taken. Notice was issued only on respondent number 1 by registered post. Respondent number 7, no process was issued. This record of no steps taken.
No, my lord, no notice was given to.
And notice was not issued, perhaps.
No, if notice is not issued, then we'll have to strike them out. If you make a prayer, we'll strike them out.
Yes, my lord, that is
Okay.
better.
In the first line, according along with the submission of Mr. Bhattacharya, first line. He expresses urgency in the matter. There you are. The learned senior counsel for the petitioner, upon instructions, has prayed that the name of respondent number 7 be struck off. Prayer is allowed. Last line, affidavit in before within 25/4/2024. List the matter on 29/4/2024. Mr. Bhattacharya, we are fixing on 29/4. The second item, item 22.
Same, my lord.
Same.
Award has been challenged.
Here,
Only I am appearing for respondent number 7.
here you are 7. So what about 8?
My lord, again, since the award has been already passed in favor of 8, my lord. So 7 can be struck off.
No, he's appearing for 7.
No, respondent number 1844 becomes respondent number 7.
7 here. So 7 can be struck off.
7 I am appearing.
Oh, 7 they are appearing. Oh, there is no, okay,
There is no
okay.
issue.
All are, it's not, okay. Here you see. Mr. A.K. Bhattacharya, the senior counsel, assisted by Mr. H. Boragohe, counsel for the petitioner. Mr. A. Thakur Danet, counsel, appears for respondent numbers 1 to 6. And Mr. J. Patwari, the counsel, appears for respondent number 7. Stop. Affidavit is any, if any, by the respondents shall be filed within 2/04/2024. Reply, if any, be filed within 25/4/2024. List this matter on 29/4/2024.
Deeply.
But no adjournment on the next date.
My lord,
Production list item 1.
Made to your lordship.
Yes.
My lord, in this writ petition, my lord, the petitioners before your lord has come for the second time, my lord. We are on a very limited prayer, my lord, here. Now, in the earlier round, my lord, what happened? This fishery, which is in question, my lord, Brahmaputra Part 2, fishery in the district of Sibsagar, was, my lord, settled way back in the year 2014, when the NIT was issued, my lord. Then this fishery was settled with the private respondent in an earlier round of litigation, which was basically intervened by this honorable court. And then, my lord, a direction was given to invite, my lord, fresh NIT. Then again, my lord, in spite of clear orders of this court, they did not went for regular fresh settlement, but again had continued to run this fishery with the private respondent for another, my lord, for completing the entire period till 2021. So 14 would have ended in 2021. So virtually, in spite of court's order, they continued with him. Now, this extension which was given, my lord.
Where is the order of 15.3?
Yes, my lord. Yes, my lord, may kindly come to the order which was passed in the earlier round.
No, which was the 15th order? Where is that?
My lord, the impugn order, my lord.
Yes.
Yes, my lord. At page 84, my lord. It is 15th of March 2024. May I read the relevant part, my lord? This is regarding the status of Brahmaputra Part 2 fishery in the district of Sibsagar, which is being run by MS Romari, so and so, my lord, on extension. In view of the order of the honorable court quoted above, the extension order is withdrawn from sitting lessee with immediate effect.
Notice, but in the earlier case, we have passed some orders.
Yes, my lord.
Will issue a notice?
My lord.
Last matter we fixed on which date, Mr. Sharma?
Lordship.
Last matter we fixed on which date?
Item number 2, my lord. 13.5.
13.5.
Similar order means lordship here in this case, appeal is pending, but then also we have development, some development.
My lord, we give earlier order was very much clear.
Mohammed, yes.
Yeah, my lord, I am appearing for the caveat, my lord. My lord, what has happened, my lord, today at 2 o'clock, this copy has been served on me.
I mean,
my lord, I need some time to go through because
I got this copy only 1 minute back.
My lord, at 2 o'clock, they gave this copy.
Just 1 minute back, just when I took out this file for the first time, I got this file only then.
But my lord, I have to take some.
But you are trained in law.
Yes, ma'am.
So if you are trained in law, there's no difficulty in understanding what is the rest of the story.
Yes. My lord, but only one thing, my lord, the order which they are seeking enforcement, that is under challenge in the writ appeal, my lord. That what order has been passed, I don't know regarding that.
My lord, the order that I'm harping upon, that is the only in the earlier round of litigation, that my lord may kindly find at page 67.
Page?
Page 67, my lord, 67.
67.
Is the, my lord, the relevant part. Here, my lord, the same writ petitioners assailed the extensions order which was passed earlier, and ultimately court came to the finding that the extensions were wrong, and the observations made is at page 72, my lord, if your lordship may come. Yes, I'll read the relevant part, my lord. 72. In view of the above, this court finds that the impugn orders have been passed in total violations of the directions passed in by this court in GOT NGO case, inasmuch as authorities were to take a fresh decision on questions of granting permanent settlement of the fishery in the light of the observations made herein above. So this is reference of the first case. Then, my lord, accordingly, the impugn order, that is 10/9/2020, this is an extension order, and 6/2/2021, reduction of revenue order. All consequential orders being arbitrary and same as.
Then we have to adjourn it. You see, we can't entertain two petitions with the same chair.
No,
Here the prayer, you see, here the observation of the court at page 72.
my lord.
Is that the state respondents are directly to take steps for issuance of a fresh NIT?
Yes, my lord.
To settle the fishery.
Yes, my lord.
So if we quash the that earlier settlement order of 15.3.
Yes.
No.
The effect is that.
No. I am not on that. Madam, may I kindly submit, my lord? The 15.3 order which is impugned today before this lordship is a consequential order after this judgment has been passed.
Correct.
So this judgment clearly, my lord, mentioned that they are prohibited from settling the fishery on daily basis. Because the last part, if your lordship sees, it is also made clear that states. My lord.
You see, the issue is that once this order is a subject matter of writ appeal, then if you pass a order which becomes contradictory to what is there before the division bench,
my lord,
will be judicial improper judicial exercise of power.
My lord.
So if you see the daily basis which has been granted to him,
my lord,
is the 15.3 order.
Subsequent, my lord.
Subsequent, but it is the order of running the this daily.
My lord.
So let us assume that this writ appeal,
my lord,
file against this writ petition stands allowed. Then what happens?
Your lordship definitely has a point, my lord.
Correct. So we just issue a notice.
My lord, then in that case, let them show, my lord, because I am the, my lord, but this is the client, my lord, who is being represented by me in the earlier round.
Correct.
So I don't have any information regarding what appeal they have filed, my lord. So if there is any stay on this order, I do not know, my lord, as on date. Because I also remember filing a caveat.
He also says he doesn't know.
Yes,
does
yes,
not
my
know.
lord.
He says that
Who has filed the appeal, my lord?
He's filed an appeal.
The respondent number 7 who was given the earlier extension, they have filed this appeal.
Which means that the order which was cancelled by this honorable court.
We record his statement, but we are issuing a notice so that we can save time. So after the vacations. Yes.
They also made a party. The one party who has filed an appeal before a division bench has also made a party here.
It's okay.
So notice perhaps on the next date.
But besides Burak Mahit and counsel for the petitioner also heard for government who is appearing, this time CTR and government advocate.
All right, now.
The case for respondent number 5, Mr. P. Sharma, Runner Standing Counsel for the Fishery Department, appears for respondent numbers 1, 2, 3, and 4. So serially, give us them first. 1 to 4, then 5. And you are appearing for?
My lord, I am appearing on behalf of the caveator, but my lord, in the wakalatnama that has been filed, Mr. R. Sinshaw's name is there. Since he is on legs in another court, so I am filling in.
No, for whom?
For the caveator, my lord, respondent number 7.
Caveator?
Yes, my lord, respondent number
6 or 7?
6 and 7.
6.
6.
6, my lord. 6 and 7 both.
Both. Okay. And Mr. K. Mohammed, counsel agrees for the respondent number 6 and 7 dash caveator. The derivation settlement of Brahmaputra Part 2 fishery. Part 2 is Roman 2 fishery in the district of Sivsagar. Wide impugn order page 84 number so and so dated 15/3/2024 is assailed in this declaration filed in Article 226 of the Constitution of India. Now, when was the last settlement made here?
Last settlement which was made here is the order, my lord, which is mentioned in the judgment, which was on, my lord, 10/9/2020, which was an extension order, which was put to challenge.
No. Earlier tender was for which period to which period?
From 2014 to 2021, my lord. 14, the NIT was issued.
Okay. It is projected that the last NIT for the fishery in question was issued sometime in
I'll mention the date, my lord. NIT was issued, my lord, on 3/7/2014.
on not on 3/7/2014.
And the
Which
order
was
of
which was for a period of 7 years ending sometime
in 2021, my lord. I'll
sometime in
just mention the
2021.
date, my lord. Which was to be ended on 7/12/2017.
Ended on 7/12/2020.
2017.
And since then, the fishery is being operated on daily basis. Next, the learned counsel for the respondent numbers 6 and 7 has submitted that as per instructions received by him, writ appeal has been preferred against the order dated 22/2024 passed in WPC 2764 of 2022 by the party who was carried as respondent number 8 therein. The said statement is disputed by the learned counsel for the petitioner on the ground that he is a caveator and he has not received any notice. Next, be that as it may, issue notice returnable on. So what was the date? What was the date last case?
13th of May.
13th of May. This one, notice returnable on 13/5/2024. Next paragraph. We take note of the fact that under the provisions of
Rule 12.
The provisions of Rule 12 of the Assam Fishery Rules, 1953, there is no provision for providing settlement of the fishery on daily basis. To stop. Therefore, it appears that by taking advantage of absence of any such clause, the respondents in the fishery department are regularly settling fishery on day-to-day basis without strict adherence to Rule 12 of the Assam Fishery Rules, 1953. Therefore, this court by an order passed today, i.e. 9/4/2024, in WPC 1911 of 2024 has made certain observations. Accordingly, court hopes and trusts that that the respondent authorities in the Fisheries Department and make all individuals to have strict adherence to Rule 12 for settling the fishery. Stop. It is also noted that the settlement of fishery on daily basis runs counter to the directions contained in paragraph 16 of the order dated 22/2024 passed in WPC 2764 of 2022. Next paragraph. it is also clarified that that on the apprehension expressed by the Learned Standing Council for the Fisheries Department, that model code of conduct is being adhered to by the Fisheries Department, for which fresh tenders are not being issued, the court has issued the returnable date on 13/5/2024 after the elections are over. Next, list on 13/5/2024.
Obviously. Now, what has emerged from the submissions made by learned friend, my lord, I have actually alleged malice in this case relating to the fact that now the parties upon whom the award has been bestowed upon is related to the person which was clearly directed by the court not to, my lord.
It's okay, we have strange.
Not so, but he had all the information of appeal being filed, my lord.
But that's okay.
That's why anyway, my lord.
It pays to be vigilant, to be
Yes, my lord.
informed.
Anyway, my lord, I'm deeply obliged, my lord.
Yes.
Production list item 2.
Same issue, my lord, we are before the court second time. My lord, I'll just place your lordship one quickly, my lord, the facts. Otherwise, the facts are narrated in the earlier judgment, earlier order, that your lordship will get it at page 82. There is a, my lord, in short, my lord, there is a delay in providing the vehicle as per the letter of
Ambulances.
award for about, according to us, 7 days, and the ambulances have been supplied, my lord, but they are not providing the site nor the road permit. This is the position now.
Who is to provide road permit?
The petitioner has to be provided with the permit for running these two ambulances, this customized ambulances they are supposed to supply. And accordingly, it has been supplied. According to us, my lord, our last date was 17/3. But according to them, it should have been 1/3, man. My lord, your lordship will can you say page 48. This is a split contract. 5 ambulances, orders for 5 ambulances were there. And the petitioner being the L2 bidder, my lord, he got it at the rate of L1. L1, even now, my lord.
No,
did
but
not
if you are offering a car,
Yes.
let us say that I know it's okay. Let us say I take a car on hire.
Yes.
So the hirer will have to take the road permit.
Road permit has to be taken.
Why?
From the
It's a consequence of a car, because
No, the
if you own the
registration
car,
has been
you will have
done. Now, road permit is required because it's a vehicle. Then
no, because you are offering a car, you will have to have a road permit of your own. Why should I, as a hirer,
but they will have to provide, my lord. They will have to say, and my lord, because I'm.
Where is the clause in the tender?
My lord, your lordship will kindly see, my lord, that particular clause I will come to page 72, my lord.
You see, because of the fact that if I don't own the vehicle, I will not get a road permit. The requirement of
Page
Motor
72,
Vehicles
your
Act,
lordship will kindly see.
page
72.
72, because
Issue of commercial registration permission and road permit to transport contractor of Bongaigaon Refinery Hospital. We would like to inform you that in order to maintain continuous and uninterrupted operation of our refinery as well as various other exigencies, there is a requirement of providing uninterrupted transport services, for which Bongaigaon Refinery maintain a fleet of
So
ambulances.
they have written it to the DTO, but they can't provide you this. You see, the
Yes,
road
DTO
permit
will provide, but on the basis of a letter of the.
No, road permit will be given only to the owner of the vehicle. Under the Motor Vehicles Act and rules.
If it is not required, it is good for me only, because
It's not
now
required,
they
because
will
you
have
see,
to,
no.
they will have to let them say so, my lord, because now 2 things are required to be done.
No, but road permit is the requirement of the owner. It can't be shifted to Indian Oil Corporation. Under the Motor Vehicles Act. Just show it to you. MV Act.
On that matter, we have no issue. But now the vehicle has been placed there to allow me to operate. We have taken loan from the bank about more than 55 lakhs. These are MSME unit. And despite order of this court, my lord, as page 82, they have not done anything.
Sixty-six of the Motor Vehicles Act.
No, I'll look. Section 66.
Okay, only issue notice at this stage.
No, my lord, only my prayer is that because my lord, page 82, your lordship will grant this.
Page 82.
82. This was the earlier order passed because they did not act on my representation. Now the vehicle, this is the order, it starts from page 83. The ultimately court said, my lord, no, on consider page 85, on consideration, considering the prayer of the petitioner, this writ petition is disposed of. The motion stage with a direction to the respondent to take a decision on petitioner's representation dated so and so. A copy of this order and the representation dated so should be submitted to the respondent number 2 on so and so. No coercive action should be taken till a decision is taken on the petitioner's representation. The representation was that, my lord, there will be a delay of 7 or 8 days in providing the vehicles. Because, my lord, manufacturer says, my lord, this is a customized vehicles. We cannot supply it within 2 months. We need 3 months time. So, but in the meantime, we are providing them the old. My lord, your lordship will kindly see page 67. 67. That is the condition. 14.1.
67.
Yes. This is the clause, my lord, and penalty clause is at page 14.1. May I just read this?
Yes.
If the contractor is not able to place the ambulance according to the specifications, model so and so, this is customized, my lord. Immediately within the specified time period of 2 months, as per the terms and conditions of the contract, the agency may make alternate arrangement for providing ambulances of model not older than so and so for a period of maximum up to 2 months from the date of the work order. This we have provided. This is still running. During this period of 2 months, the percentage of profit will go down. In case the agency, my lord, below, my lord, proviso, in case
No,
the
but Mr.
agency.
Das, you see, you come to page 86 of the
86.
writ petition.
86.
86 is that you are given a formal notice before termination.
Yes.
Last 2 lines.
Yes.
Yes. So after that, after notice of termination.
That is on the same date of the order of the court.
That's okay. But
On the
once-
same day order was passed.
No, I understand. But you see, notice before termination is issued. So we can't create a contract.
No,
No.
no, they have not done anything on persons to the order of representation, order of the High Court. There is an order not to take any coercive action. But in the meantime.
That has already been issued.
No,
You have annexed it, page 86.
that is notice only, madam.
Correct.
That is on the date when the order of the
Today
court was
we can
passed.
only issue a notice. We can't do.
What I am
anything
saying,
more.
my lord, will take dusty service. Your lordship will issue notice. I'll pray, my lord. But in the meantime, they should not terminate my contract. That is my prayer, my lord. I'll leave it to your lordship.
No, because if termination is made, you can only have a right to recover compensation.
No. My lord, we have supplied the vehicle. Your lordship will take into consideration.
I'll tell you why.
My lord, these are MSME unit. My lord, there is a delay in supplying the vehicle.
No, that's
by
okay.
some-
But
My lord, your lordship will issue notice, man. At this
we
stage.
have a limitation. I'll show you why.
But pursuant to the order passed by the court, no action has been taken till date. Contract statement.
No, specific relief act. And under 14 D, the agreement which is otherwise determinable in nature, they can't be enforced.
My
So
lord, but
therefore-
here, this is an arbitrary action they have taken. Because my lord,
I
your lordship
understand,
will
but once
kindly
this
say,
notice is issued, we can only issue a notice.
no, at this stage, your lordship will issue notice, for interim, your lordship will fix a date.
Yes, okay.
And I will take justice service.
Okay.
Because otherwise, the earlier interim order protects me also. It takes, my lord, no coercive action shall be taken against the till decision is taken by the under petitioner.
Heard Mr. B. Das, the senior counsel, assisted by Mr. S. K. Sharma, counsel for the petitioner.
Entire ESD has been deposited. My lord, your lordship may kindly note that the vehicle has been placed on 23/4. And they are not taking any action for the purpose of running of the vehicle. 23/3, man.
Agitating that despite order dated, which page is that order?
That is at page 82.
Despite order dated 22/3/2024, passed by this court WPC 1719 of 2024. Neither the
We have placed the vehicle. After the order, we have placed the vehicle.
neither the vehicle placed, ambulances placed by the petitioner was accepted, nor they are permitted to operate it. The present petition has been filed under Article 226 of the Constitution of India. By also alleging that despite the order of the court, the representation of the petitioner has not been disposed of. Issue notice, including notice on the prayer for interim relief, returnable on. You sub by Dasti,
Yes, I'll find.
number 24/4/2024.
Yes.
The petitioner shall take steps for service of notice on the respondent by registered post in AD, as well as serve notice on the respondent number 3 by way of. So 3 will be the person
All
five?
can, I think,
5. 3 or 5.
3 and 5, 3 and 4.
3 and 5.
3 and 5.
By 3 and 5 by way of Dasti, by routing the process to the register of the court and upon service and.
And others by
ticketing
registered
of
post.
service shall be. This will be 5 prior to the next date of the state. Next list on 24/4/2024.
For interim order.
For rest.
Consideration
registered post to the AD. Returnable on 24/4. Yes.
For consideration of the interim order.
I said issued notice on the interim prayer for interim relief.
Item 23. For orders.
Yes.
Lordship, this matter, they are asking for remission of the case money, Your Lordship, which is not permissible under law, Your Lordship, not a minor concession rules, Your Lordship. In fact, they made a representation before the DFO. The most competent authority to take the call on that is the PCCF, Your Lordship.
The petitioner is not there. Non-appeasement call for the petitioner, Mr. R. Devil, standing counsel for the Forest Department, submits that the prayer for remission is required to be considered by the government.
PCCF.
By the
PCCF, Principal Chief Conservator of Forest.
Respondent number 2, is Principal Chief Conservator of Forest Society.
Head of Forest Force. Respondent number 2, Your Lordship.
And?
And Head of Forest Force.
And Head of Forest Force. Respondent 2. But here it is sent to whom?
The representation have been submitted to DFO, Your Lordship.
But in this case, it is submitted at the representation was submitted to the DFO. Be it as it may, as the petition is found absent on court, that is why John today. We stopped answering the petition.
Public.
24.
Happy to lock it.
Yes.
As per the earlier order, madam, the time was given to file a counter, madam, with the affidavit in opposition filed by the government of India. So, madam, I have received the Paris comment, madam, some instruction, madam, that I'll file an affidavit, madam.
Just a moment. Where is the order of this court?
At page, madam, 11, madam.
One.
Page 11, last paragraph, madam.
You are appearing for?
My affidavit, we have filed our affidavit on 24/11, madam, 2022. Response number 1. And in this regard, madam, we have also passed a speaking order. The Lordship will find the speaking order at page 36, madam, annexure 8. But there are some objections regarding his bill, madam.
Lordship, let them have to file the affidavit, Lordship.
This is a wrong forum to make that submission. We are in contempt jurisdiction.
Yes, ma'am.
I can't go behind the order and find out what is right, what is wrong. If you find that the order is not compliable, you should have applied before the court for modification of the order. That you have not done.
But the order
Once you
was
accept
passed.
the order. Once you accept the order, we hardly can go behind it and then find out why.
But the order was to verify the amount, madam. We have verified it, madam, and found it to be objectionable, madam. But they are supposed to submit the bill again, madam.
No, the order of this court is at page
11, madam.
11.
Madam.
And if after verification the petition is found entitled to the amount claimed in the petition, to the extent of so and so, necessary to be taken for release of the amount.
Madam.
Correct.
Madam.
So where is your exercise?
Exercise is at, madam, page number, madam. At 36, madam, of our
36.
Affidavit in opposition, madam. Lordship may come to page 38, madam, directly, the last paragraph, madam.
Mr. Das, doesn't make a sense.
Madam.
You, in this document you are showing us, you are referring to annexure 9 and annexure 10. When we want to read those annexures, it's not available. It's not taking us anywhere. This, you are referring to this reply. You showed us which page? Page number?
Annexure 8, page 36, madam.
Page 36.
Madam.
930, page 36. If you turn to You see 36, 37, 38.
38. 38 my last paragraph, my lord.
Correct.
Yes, my lord.
So you see, I read page 36, I read page 37. Now I come to page 38.
No, last
You are
paragraph.
referred to that first paragraph. You say that you have your next copy, annexure 9. So that annexure 9 is not available.
No, last paragraph, in view of the above, the claim of petitioners, so and so. has
I
been-
start reading from first paragraph, then I end to come to an end. Page 38, first paragraph.
Yes, ma'am. Whereas portal claim number so and so could not be authenticated. Yes, ma'am.
Read it completely.
Whereas portal's claim number so and so could not be authenticated by the claim verification committee due to submission of insufficient supporting documents and due to duplicacy of claim bill submitted earlier. It's their fault, madam.
Now you see, if you don't have supporting documents, first number is annexure 9 is not before us. We don't know what you have written. So we are withholding documents even in a contempt petition. That's one. Number two, if you don't have authentication, you are directed by the court to do it, to complete the exercise within 3 months.
Yes, ma'am.
Who has asked you to wait? You could have rejected it.
But we have requested them to resubmit the bill. But they are not submitting it again, madam.
Why they will do it?
Lordship, no
They have
formal
an order
notice
of
was
the court.
issued to submit the same, Lordship.
So once you are disturbing, we'll take it up some other day. Matter stands adjourned today on the claim made by Mr. S.P. Das and Constable.
Lordship.
Respondent number.
I'm.
No, this Mr. Das is respondent number. One. Mr. R.K.D. Chaudhary, DSGI appears for respondent number.
3. Lordship, advocate for 3.
Advocate for respondent number 3. Okay.
I have got approval.
KK. Mr. Rashid, responsible respondent number 3 at present.
Lordship,
Never disturb. I'm asking questions in your favor. If you are about to ask things, then you are disturbing.
Lordship, only
No, it's okay.
simple submission, Lordship.
You make
Similar
submission
matter has been
from
pending here before this on.
after answering disturbing is something we're not accustomed to.
You have blessed, Lordship.
25.
The court is speaking in your favor, then you start disturbing. Yes.
May it please, your lordship. It's a contempt applications wherein the amounts are admitted. And on the last occasion, that is on 3/4/2024, this honorable court directed them to file an affidavit indicating as to why they failed to pay the amount within the stipulated time. Secondly, the court also directed that as to when they would make the payment to indicate the date and the time when they would make the payment. But they have, although they have filed an affidavit today, but they have not indicated anything as regards the directions so passed by this. honorable.
Today I have filed, madam.
Today. It's not on board. Affidavit is not come. It is after vacation. Let that affidavit be there. It's a contempt proceedings. What says the representative? Mr. N.J. Khatunia, counsel for the respondent, submits that the affidavit in opposition is in filed, which is not on record. Filed today, which is not on record. Let the said affidavit be checked. Based on 24/4/2024. Lordship. Do you have a copy in your first affidavit? First your affidavit, please.
No, Lordship.
I have a joint affidavit. That's in that.
Extra copy.
But they issued a sanction letter. Let us wait for some time. They've issued a sanction order.
But sanction was issued, but it was lapsed because my kindly come to page. My sanction is at page 121, and the reason for lapse 122, my lord. 122. Last page of the affidavit, my lord. Sanction was granted on 13/3. page 121. It was granted on 13/3.
You see, we are adjourning it till 24th,
Yes, my lord.
correct? You better write to the finance department telling about the contempt case. And you disclose us the name of the persons to whom we are writing. If the finance, despite knowing that there is a contempt, lapses the sanction, you file an affidavit, bring it on record, you give the names of the persons who are involved in the finance department to have it lapsed.
Lordship, I am appealing for respondent number 2. He is no longer serving, but Lordship, here, the gist of it is the proposal was sent somewhere in the year 24 only. Before that, no proposal was sent regarding payment to the petitioner, my lords. So finance department's role was triggered then, and then 13th of March, we had concurred with the sanction. And it was not just regarding the petitioner, Lordship, the proposal was amounting roughly around 84 crores, not just for the payment to the petitioner and others. So it was a huge proposal. Now, since the finance had concurred in 13/3, but after that, the sealing proposal was not sent on time by the education department, because of which.
That's why, you see, I'm giving, you see, we are taking up next on 24th.
Yes,
correct. In the meanwhile, they will write correspondence and then.
Yes,
send it to us. And we will see on that day what occurs. Correct. Sure, just make a reference. Say, hey, Shadia, then a council request for respondent 2.
Your Lordship, I'll just indicate one thing, if your Lordship permits me kindly. In the order at para 11, there is a direction that the proposal is directed to be prepared expeditiously and forwarded to the finance department for sanction of the required fund. Such exercise is directed to be completed within 2 months from the date of the receipt of the said.
That's okay, that's why we have read
And
that order,
we
that's
have
why we are.
given the copy on 11/11/2021.
They have understood what I'm trying to indicate. Both of them have understood what we are trying to indicate. They can come in.
Only
26. Yes, sir, notice by Dusty on respondent 4. Served. Affidavit is filed. Okay. Yes, you are appealing for?
I'm 1 to 3, my lord.
1 to 3.
Vacation may have admission.
You come for admission now. Yes, what is your stand?
My lord, we said that the petitioner died after, after his, this scheme is available to the, my lord, to the employees who, well, if they died during the period of service, my lord. He resigned on 7/12 and.
But his disputed
he
resign.
7.
The respondent number, the respondent number 4.
Yes, my lord.
Has denied that he has resigned.
That is why, my lord, on last occasion, they were directed to make Dusty service.
No, but they have not appeared.
Yes, my lord. Let it now after vacation.
Chairman protest. Attended of it was 7/12, your Lordship. After that, there's the Saturday, which is the Sunday, therefore it's not appeared. 19 is due to calf protest, protest, which was
On tenth, he expired.
Yes.
There's no question of reject. There's nothing to reject. They by mistake, they do not. put in-
And what is the document on based of which you say that he has resigned? Mr. Chakravarti,
Yes, Madam. That's fine.
They rely on document. They repeat it. Case 41.
Annexure 41, which says, my lord, date of leaving service 7/12, away from service.
It's not reject.
41,
Page 41, Annexure A.
application for monthly pension.
And, serial number 8, my lord, 8. 6 and 7.
Reason for leaving service.
Not reject.
Who is the author of this document?
It's
Both, my lord, the applicant and the applicant Rita Chetri. Petitioner herself.
Date of death, 10/12. It is a form, you know, subsequently they have clarified that. Correction.
Now, what is this CM, HO and CO? What does it mean?
Penny or
CM, HO and CO. There can't be a name like that. CM, HO and CO. There's no full name. There's no full name.
Is 6 from I.
Makum is a very small place. I have not visited Makum. How big is Makum? Nobody, anyone having knowledge? Makum? Near Tinsukia. Is it small place or town or something?
It's a small town just nearby Tinsukia, my lord.
No, I understand, but it's a
small town.
small town.
Size of the town will be somewhere smaller than Tejpur, my lord.
Smaller than Tejpur.
Yes.
No, I'm asking because of this. Oh, you have served by Dasti.
My lord, apart from the Bargola there in Makum, and if you play shops here and there, my lord, it is basically it is surrounded by tea gardens.
I get it.
Nothing of substance is there.
No, I get it. But no, it's received by hand, so that's okay. Because the address is only Pio Makum, Tinsukia. So there, the
Perhaps
service
there
can
it
be
can-
made or not.
It can be.
It can be.
It can.
Okay, okay. Thank you. Where is the last pay slip you received? Your husband received?
7/12.
Hmm?
7/12. 7/12 is last attended. After that,
No, pay slip, every day you don't get payment. Payment is monthly. Where is your terminal pay slip? Then no, you see, here is a case where you retired on, what you call? No, it's okay. 7/12 is the last working day. You died on 10th. And the,
and it's attendance registered level. That you understood?
you see, please understand, we don't know that. Attendance registers and all, we don't know that. But you receive a pay, there could be some acknowledgement of pay that last pay you will get on the day of termination. After death also there is a termination. I can't pay a ghost. Salary will not be paid to a ghost. So therefore, you're on some day when you die, that will be the date of termination. So if you are working, the date of termination will not be 7th, it will be 10th. Your employer is not coming forward to tell us. So we'll have to gather from your documents only whether you are working or not on that day. Your employer is not coming here.
Yes, 15, I have NS attendance registered. 16.
We'll permit you to make an inquiry. Make a physical inquiry.
Well, inquiry report, my lord, we have annex, an inspection report, page 49, my lord, annex B.
49.
Yes, ma'am. And there is let's see.
No, he did not do any visit. He just look at the documents and then you're saying it.
No, my lord, page 53, with can you see?
Page
53.
53.
Annex C, my lord. The type copy original.
How does this man says that he left service? Now, please tell me, let us say A, he is a staff in the court.
Yes, ma'am.
He goes home at 10 o'clock, he dies.
My lord.
How will that death be reported? Death in service or death away from service? So what is wrong if somebody says death away from service? That means he did not die in the office. If somebody has resigned,
yes, my lord.
There'll be a document of resignation.
Yes, my lord. But if we go by the date of birth, my lord, which is 64, then he would have retired on 24, my lord. But he left service on
Left you see, I leave for home.
Yes.
I tell all my people that I am leaving for home. Does it mean that I have left my service? Whenever I go, I have a habit of telling all my court staff that I am going home. So therefore, if it says that sir has gone home, will it mean that I have retired, taken a voluntary retirement and gone home? And if I go home, shall I say that I am in service? Tell us. So what is this inquiry you are trying to make? You don't even ask the officers that if he has retired, even if he has resigned. There's a letter of resignation.
No, that we have not next tenure.
That's why you see, these are all tabletop exercise.
Let it come after vacation. Madam.
No, we show direction. Let your inquiry officer go there, have physical visit, collect the what you call document of leaving service.
Yes, sir.
Correct. And tell us within this month, and we'll take it up on 1st May. Mr. S. Islam, counsel for the petitioner. So Mr. S. Chakravarti, counsel for the. No, you said that he also submits that notice has been served on the employer of the husband of the petitioner, i.e. respondent number 4, by way of Dasti. However, the employer has not appeared in the court, despite notice being served. And in this regard, he is referred to the affidavit of Dasti service filed on 7/4/2024. Next paragraph. From the stand made in the affidavit in opposition by the respondent numbers 1, 2, and 3, it appears that merely because of an entry made in the claim application by the employer, in the, where is that page? Yes, 41. 41. Claim application for monthly pension form within bracket, page 41, annexure E to the affidavit in opposition of respondent numbers 1, 2, and 3, bracket closed. In column 4, the column in row in column 7, inverted commas, death away from service, comma, and inference is drawn that the petitioner, so the husband of the petitioner, namely Govinda, Gobinda, Bahadur Chetri, Chhetry, has either left or retired from service. Full stop. The next paragraph, the explanation of the petitioner is that on 7/9, sorry, 7/10, 7/12, 7/12, 2019, he last attended his office, which was a Saturday, and next date, i.e. 8/12/2019 was a Sunday, and on 9/12/2019 and 10/12/2019, the office of respondent number 4 was closed due to CAA protest. And on 10/12/2019, the husband of the petitioner had expired. Full stop. Although, next paragraph, although the respondent numbers 1, 2, and 3 have produced the inspection report, but more from the inspection report, it can be seen that the person making the inquiry had spoken to the management and staff of the respondent number 4 to ascertain as to whether the husband of the petitioner had actually retired or left service. Full stop. In both eventualities, it is expected that there would be documentation of the husband of the petitioner either resigning from service, and if he is superannuated, comma, there will be record in the respondent whose office of the petitioner being, husband of the petitioner being superannuated. Full stop. Next, under such circumstances, comma, the court does not find the inspection report dated 5/8/2021 as a reliable document. Full stop. Therefore, the court is inclined to direct the Employees Provident Fund Organization to cause an inquiry regarding the deceased Govinda Bahadur Chetri, comma, UAN 1001541028893, comma, PF account number capital NETSK 0000893000 oblique 0000084. Who at the time of his death on 10/12/2019 claims to be an employee of a firm under the name and style of C full stop, M full stop, capital HO and CO at Martin Junction. Next para. The respondent numbers 1, 2, and 3 are further directed to take note of composite claim form in death cases in bracket annexure 2 to the writ petition, comma, letter dated 3/7/2020 within bracket annexure 3 to the writ petition, comma, letter dated 26/9/2020 within bracket annexure 4 to the writ petition, comma, letter dated 26/2/2021 within bracket annexure 5 to the writ petition, joint declaration, comma, undertaking within bracket annexure 7 to the writ petition. So the said inquiry shall be conducted within 30/4/2024. Next, to enable the Employees Provident Fund organization to carry out the inspection of the verification, the learned standing counsel for the respondent numbers 1, 2, and 3 shall send a downloaded copy of this order to the competent respondent authorities to enable them to do the needful. Next, list on 3/5/2024. Because if I think today when I'm sitting, if I think that I'll dismiss this petition and then hear you, let us say that today I've made up my mind that this petition I'll dismiss, and then I start hearing you, then I'll find 101 ways to dismiss it. But you see, you go to an employer, ask him whether this man was alive on that day. Supposing somebody writes, I've told you the reason, explain it to them also. Because when I go home, I tell my staff that I'm going home. Can somebody interpret that Lordship is going home means that he has retired, he's taken a voluntary retirement and gone home? Correct. You can't draw that presumption because these are documented eventualities. If somebody resigns, there will be a document of resignation. These people, why they write it? You know why they have written it so? Look at the name of the person who is signing it. Is some D, L-E-E. Correct. So he doesn't want to take the responsibility. He said somebody died outside, so he said that he died outside. Died outside does not mean died outside service. He died outside, he's not taking responsibility of somebody dying in the premises, then he'll to have face consequences. Correct. Please understand, make them understand these few things. Surname is L-E-E. Either it's an Indianized, what you call Chinese.
Yes.
Therefore, it doesn't take a responsibility. He just says that somebody died outside. He just says died outside. Outside doesn't mean outside service. That you are saying so yourself. You're presuming somebody died outside service.
Death away from service.
Death away from service, yes. You see, you are dealing with these matters for quite a long time. What is the interpretation given by the courts? That if somebody goes for employment and he suffers an accident, that is in course of
Yes.
In course of employment.
Yes.
Correct.
Yes.
So then what does a person do? He is an intelligent man. He says that he died outside service. That means he was not traveling in course of service, and therefore when he died, no responsibility of the officers. Make them understand these things. You know insurance very well. We will not expect it from you, not to explain it to them. Correct. That is the logic. Somebody dies outside, somebody is writing, very fairly is writing outside service. That means he's not in course of employment.
Yes.
Make them understand these few things. Yes, item 27.
27.
None appears on call for the petitioner. It appears from the order dated 19/12/2023. That the counsel for the petitioners have withdrawn their wakalatnama. For instance, this is the matter was adjourned on 19/12/2023 and on 22/1/2024. None appears on call for the petitioner. Therefore, it appears that the petitioner is not interested to pursue this writ petition. Accordingly, this writ petition stands dismissed for non-prosecution. And there before that, it also appears that despite several opportunities granted, steps for service of notice on responding before was also not taken. So then therefore, it appears not fixed. This will for non-prosecution.
28.
Yes, you have served notice.
But from the last day, the honorable court had directed us to take.
We have seen that you have
Justice service, but unfortunately, we could not establish communication with the petitioner, but now sometime maybe given, we'll complete the service of justice.
So you only we merely want an adjournment today.
We'll take steps for the next day.
Okay. Mr.
G. Kaushik.
G. Kaushik, counsel for the petitioner, undertakes to take first steps within how many days? First week of May to take steps. No, that much.
Any date, Your Lordship.
Taking steps is, if I ask you today, you can let me take it today. What is the difficulty in taking steps? I think that's by 10/4/2024 for service of notice on the respondent by way of the SC. Stop. The notice is made returnable on 6/5/2024. By routing the process to the registry of court and upon service and affidavit of service. The notice is made returnable on 6/5/2024. List on 6/5/2024.
29.
My lord, in fact, in this case, perhaps the petitioners are not interested. My lord,
I was having an impression that you have threatened them outside. No.
my lord, what has happened? In fact, my lord, this case, my lord, has been rendered infructuous. And my lord, I was expecting that they would apprise the honorable court for closure of the same. My lord, if your lordship finds the order 18/3/23 in the
Yes.
contempt application,
Yes.
by that order, my lord, 5 cooperative societies were dissolved.
Yes.
And one-man committee, my lord, were appointed for, my lord, holding the election.
Mhm.
Now, there was a parallel proceeding. This, apart from this contempt application, parallel writ proceedings were instituted, writ petitions, my lord.
Okay.
Now, those, my lord, orders, that order, particularly that order was upheld by your lordships, and that order has been accepted by them. So, essentially, this order was challenged being contemptuous, my lord. So, that, my lord, does not, my lord, exist now. And pursuant
Okay,
to
we'll
this
just note
order,
we'll just note your submissions.
my lord,
We'll
lordship
adjourn
have
it.
noted, my lord, and pursuant to this order, my lord, elections has been held. Now, new board has come in. Now, nothing survives.
Okay. Mr. None appears on call for the petitioner. Next para. Mr. S.K. Talukdar, standing counsel for the.
In fact, in this case, I am appearing for respondent 1, my lord, contempt application.
Okay. Then counsel appearing for respondent number 1
Register of-
has submitted that this matter has become infructuous. Full stop. In this regard, he has submitted that the order of this court dated 23/9/2021 passed in WPC 4717 of 2021. Had been upheld in the writ appeal.
No, my lord. In fact, this order was alleged to have been violated by the order of the additional registrar 18323.
Okay.
And that order, my lord, has been upheld in a parallel proceeding to the contempt application, my lord.
Okay.
That writ petition, I don't have the number
No,
right
okay,
now, my lord.
it's okay. Which document you are referring to?
18323 of the additional registrar
Okay,
Kokrajhar.
Pursuant to which the assistant registrar of additional registrar of cooperative societies, Kokrajhar, passed an order dated 18/3/2023. Stop. Next, it is submitted that parallel to this contempt petition, another writ petition was also being.
5 writ petitions were filed.
5 writ petitions were filed from time to time.
Yes. Challenging this order, my lord.
Challenging the order dated 18/3/2023. So, however, the said orders have been upheld in those writ petitions.
My lord. An election has also been held pursuant to this order 18/3/23.
The petitioners, the petitioner in this contempt application has accepted the said order, and pursuant to the disposal of those 5 writ petitions, elections have been held in all the 5 cooperative societies which were taken over by one-man committee. Hence, it is submitted that the cause of action for contempt does not survive. Next one, be that as it may, as the petitioner is found absent on call, notice that John as a last chance. Next paragraph, it is made clear that if the petitioner remains absent on call on the next day, my adverse orders may fall.
Deeply obliged.
Yes.
In this case, well, notice has been issued, but the respondent number 2 and 3, instead of appearing before my lord, they have issued certain communication to the registrar. Office note 5/4/24.
Mr. Bhoglia. You see, this is what is happening, because then we have to initiate contempt. You got a notice of contempt and they are writing very conveniently to the registry, sending the para with reply. Can you take note of these names and then make communication privately? Otherwise, we'll have to issue, we'll have to initiate contempt.
I will try to communicate.
Take the notes. Take the address and make a communication.
May I have a copy of this letter? I'll
give it to
this letter.
He says
Letter I don't have. I don't have this letter.
No, that we can't part with because they are sending it to the registry.
My lord.
But you can note the names of the contemners. Since they have written to it, we'll have to, you see, the consequences is, Mr. Bhoglia, the consequences that we'll have to reject it and initiate contempt against them. They are your officers. Mr. M.R. Khandekar and counsel for the petitioner has submitted that although notice of contempt was served on the respondents, but instead of filing an affidavit, they have made a direct communication to the registry, which is made a part of record. The court is aware that in a contempt proceedings, the counsel will have to be engaged by the respondents. Nonetheless, Mr. G. Bokalial and a government advocate who is present was asked as to whether the government officers on receipt of contempt notices are under any direction to send the paravised comment to the court. Now, the government advocate pays for some time to obtain instructions.
A copy of this order may be available.
Yes. To stop. Therefore, as requested, the Mr. G. Bokalial and the government advocate is permitted to send a downloaded copy of this order to the appropriate authorities to obtain instructions. Next paragraph. For that, next paragraph, for the limited purpose of obtaining instructions, the registry shall reflect the name of Mr. G. Bokalial and GA in the cause list by listing the matter next. Next paragraph, list on when
Has to be week of May, man.
first week.
First
This
week.
one 3/5/2024. Next paragraph, the pendency of this contempt petition shall not be barred for the respondent authorities to comply with the order of the court.
RT1.
It come in addition column. Okay. You miss M. Das. Miss M. Das, then counsel for the petitioner. Miss Sujila, counsel for respondent number
1, 3, and 4.
1, 3, and 4, and Mr. A. Shadia, and counsel for respondent number 2. It is are present. You're appearing for 4 also.
Yes, Lord. On behalf of Mr. Tar.
No. In the last case, you said that you're not appearing for
Yes, Lordship, they have sent a letter to us, Lordship.
Oh, okay. Next, as it may, the notice on respondent who is otherwise served. Next, as the case is ready as regards service, list the matter in the admission column after the entering the application.
RT2.
Lordship, Mr. Esbra is on legs. He is praying for 2 weeks' time as instruction is awaited.
Just a moment. This last time also, this time was granted. Okay. The petitioner and the respondent numbers 1 to 4 are represented on the clear made by learned standing person for the BDC. The attestant is John today. List after 2 weeks. For which time the affidavit in opposition shall be filed by the respondents. During which the matter would be heard on the basis of materials available on record. Next, interim order passed early stands extended to the next date of listing. Interim order is extended 2 weeks time we are granting. Date after 2 weeks is very impossible. You make a mention because we will not be able to handle after every vacation. No, I understand.
He is neither he is coming, appearing in position of the court, nor he is executing the work.
No, that's okay. That's why we are extending that, we will record the actions. But immediately after vacations, 1 or 2 weeks, we are in a limbo, we can't do anything. For last about 10 days, we are fixing all matters after vacation.
Yes.
Then, if I fix a date, you have seen the viral news. Managing of cases listed, 1600 cases listed in before one court. You have seen that. I'll be the same recipient. Every day there will be more than 1,000 cases. I will not be able to handle. After vacation, make a mention.
No.
Item 33.
Here, I have submitted. File the affidavit.
My lord, in this method, the respondent PPCL has filed an affidavit on Friday method. We have to file a reply method. Because certain statements we have to rebut method.
I have taken the plea, my lord, that he has suppressed some material fact, my lord.
It's okay, let him respond.
Oh, there is an intent, my lord, that's why, my lord. Can it be?
In the second half of Friday only, I have received.
You make a mention after vacation.
Yes,
You
sir.
do not fixing a date.
Yes, sir.
Outside the represented. The service is complete.
Service is also on respondent number 5 is not complete.
Who is responding to 5?
Respondent number 5. Is the beneficiary if the election of the petitioner is get himself, my lord, for the RO dealer.
May I submit, before I to see whether this petition is maintained in the present form, because the petition has been filed by misleading the court, my lord.
Is?
But the petitioner, my lord, by misleading the court, my lord, able to get the interim order, my lord. Because, my lord, his ground is there, my lord, because he has not received one email, my lord, but he has received, my lord. He visited, the petitioner visited our office, my lord. We have shown him the in his email, my lord. What he has done, my lord, he has deleted his email, my lord, and it kept in the trace folder, my lord.
No, my lord, it is false, my lord.
Well, I am providing the video also, my lord. My lord will see, my lord. But the petitioner visited our office, my lord, and we have shown him, my lord, how he has deleted.
If you are showing video, we'll post it tomorrow. Tomorrow is the last day. We'll look at this video.
My lord, there is a technical question also, whether when the mails are moved to the trash folder, my lord. It is not that only when the mails are deleted, it moves to the trash folder, my lord. Because due to certain filter or
No, we don't know, but video will something before every vacation, we encourage lawyers to bring videos. We'll see videos on the last day.
Yes.
I can assure you, I can spend my time looking to that video for the entire day.
It's a 15 second or 20 second, my lord.
No. Why 15 seconds? I have to see once or twice, thrice.
And he says that he's not a tech savvy
Yeah,
man.
before vacations, we are doing it. Tomorrow you fix it. You just inform the members of the bar sitting behind that tomorrow will be the day for video after vacation.
But all communication is made through email, man.
No, that's okay. But we just can't. We can't deny that opportunity of filing an
Yes,
counter.
that's true.
Both sides are represented. No, sorry. Petitioner and the respondent numbers 1 to 3 are represented. You are appearing for 4 also.
That's why he has a. I can appeal, man.
No, not I can. You have already appeared for 4. Bhakaratam is already filed.
Yes, man.
Now,
affidavit filed on behalf of respondent 2 and 3, man.
No, that we don't know.
Yes, man.
Your Bhakaratam is for respondent number
2 and 3, man.
No.
20 condition. Huh? Condition.
2 and 3.
2 and 3. Condition.
And 4 also.
Yes,
4.
sorry, man.
Why you're making us spend time? For 4 who's appearing, Mr. Roy.
Lordship.
Petitioner, respondent number. Mr. Roy will also appear for respondent 1.
Yeah.
No.
1 Lordship.
Union of India.
Yes, D Das appears, Lordship. D Das appears. Rupert Das is appearing in this case.
1, 2, 3, and 4 are represented. What's the matter? And for the Lausima port. For passing appropriate orders on as regards service of notice on respondent number 5. Next one. The learned counsel for the petitioner, place for is granted. 2 weeks time.
Yeah.
To file affidavit in reply to the affidavit in opposition filed by the respondent numbers 2 and 3. Affidavit shall be filed within 20 days time, within 22/4/2024. Use this matter on 29/4/2024.
But 29 4 I will be available on
1st May 1/5/2022.
My lord, interim.
About the past years extended till next for this thing.
34.
Number 2 and 4. 2 and 4. No, I'm appearing for it now.
Yes. You are appealing for?
Respondent number 2 and 4.
Respondent
2 and 3. Sorry.
2 and 3.
2 and 3. 4 is the private respondent.
Is the private respondent.
What do you say about this clauses 4.3 and 4.5 non-compliance?
Yes, my lord.
That's it. That I have received instruction, the first point in the last order dated 14/3/2024 of this honorable court.
Yes.
The pages 153 and 155, there is a mistake actually while pointing out. This is one is financial year and one is assessment year. That's why there is difference, definitely. And just by comparing page 153 and 155, your lordship will find.
153.
Yes. They are saying that the amount for the year 2018-19 are different in both the
No,
turn
that's not the case.
153 of the petition.
No, no.
For the same period, might
Two different amount. That is their plea.
different.
Where is this 4.3 of the contract? Where is that? 4.3?
What's it will find at page 39.
39.
39. 39.
Four point three point
4.3.5.
5.
Yes.
4.3.5. Reports on the financial so and so.
Yes.
You say it's not been complied with.
They have submitted.
What is your?
They have submitted. They have submitted. This is my instruction. They have submitted. I'll file a detailed reply and affidavit in reply.
No, but today is the date fixed for considering of India interim order.
Yes, your lordship. For that, I am submitting. I have the instruction that they have submitted all this. So
Okay.
this plea
And
is not
4.3.6C.
that also. The network certificate.
That network certificate you lost.
4.3.63.
Yes.
Where is that?
6C
6C.
at page 40.
Yes,
40.
The bidder should submit.
4.36C.
6C you lost. The bidder.
Where is that? 6C, huh?
6C.
The bidder should submit net worth certificate of minimum 10% of the so and so.
Certified chartered account.
Yes. These two documents, as per information instruction received verbally, today I have filed a call on my lordship.
What is?
They have complied. So there is no
4.5.
irregularity on that part.
And 4.5 you also. There are also some criteria mentioned. The second one, 4.5 in the same page. Bidders must submit audited balance sheet in support of his financial credential for the last 5 years. That audited balance sheets that were not supported and auditors reports were not supported, so that was not submitted so far. And that the routine you know. If it is a one rule, then the number is there.
Okay, once he's making a submission, we'll record that.
Yes.
But Mr.
D. Bora,
D. Boral and counsel for the petitioner. Mr.
PK Sharma.
BK Sharma, learned counsel enters appearance for respondent numbers. For respondent numbers
2 and 3.
2 and 3. And he submitted that he has specific instructions to the effect that the respondent number 4 who is the successful bidder has complied with clause 4.3 within bracket Roman 5, comma clause 4.3 within bracket Roman 6, again within bracket Roman small c, and clause 4.5 of the NIT. So we submit that he has filed his Vakalatama today and please for some time to file an affidavit. The court reiterates that it's not required. Affidavit by will file by 24th April. Affidavit in opposition by the respondent numbers 2 and 3 should be filed within 24/5/2024. This is the matter for 26/4/2024, consideration of mayor for interim relief. Next point is reiterated that the allotment of contract work to the respondent shall be subject to outcome of the petition.
Subject to.
That is already there.
Yes, it's okay.
For CGC, for respondent 1 will be appearing
Private response delay नहीं किया आपने?
No, Union of India is, I think, first, State of Assam. Okay. State of Assam. It's not a lot, it's zero. No, we are just saying, we are reiterating that the allotment order is subject to outcome. That is the last order we have reiterated. But since he says that he has instructions, we have recorded that.
Yes.
So, and we fixed the matter for consideration of infant pair on 26th. 26th.
For hearing, item 37.
Again,
How is the health of Mr. Bapataki?
otherwise well, but day before yesterday again slipped. So again slipped in the bathroom. So some minor injury again there. Actually today I came to the chamber. He don't entered the chamber in the vehicle. Otherwise he is fit and fine, but not in a position to come over board and conduct the arbitration. Business is there.
But today we hardly have time to start hearing. Roadside stall.
Yes. Actually, this field is not anything that is the stall, but behind the back there are some vacant premises regarding that portion already.
Okay, we'll fix it for hearing because today we can't take up. Maybe possibly time matter could not be taken up today. Just on. This is delivery.
What's that?
This tarikh.
8 April.
23/4/2024. Outside the representative.
Can it be on 24th or 25th?
Can be 25th by Thursday.
25th.
Yep.
38.
Yes.
Seems that it is same order.
Same, other date without.
Okay.
16th of May, my lord.
This is 2023 matter.
Yes, brother.
30 April. 30.
April.
Same order. Which is represented. Specific feedback.
Perhaps, my lord, there will be a thunderstorm.
Huh?
Perhaps there will be a thunderstorm.
No, I don't get it.
I said perhaps there will be a thunderstorm today, my lord.
We don't know. I mean,
When
act of God.
No, but when such frantic starts is being made for.
No.
books and being
No. Because in my courtroom, I have